authorities initiated the process to recover the excess payment made to the petitioner from 1/8/2000 to the date of his acquiring the PhD qualification, full stop. Further, it was also noticed by the department that since he had been allowed to draw the salary on a pay scale instead of at a fixed pay or the minimum of the pay scale, comma, his pay had to be re-regulated and the excess of salary drawn to the date of the issuing of the to the date excess of salary drawn was also required to be recovered. In such circumstances, the principal of the college was required to submit a data sheet depicting the recovery required to be made from the petitioner, full stop. It is at that stage that the petitioner has approached this court with two grievances. Firstly, the petitioner has assailed the attempt to make a recovery of alleged overpayment of salary, and secondly, he has sought the directions for payment of for fixation of the salary of the petitioner under the 7th Pay Commission and for grant of notional benefits of upgradation and promotion from 2012 in stage 2 from stage 1 in 2017 from stage 3 to stage 2 and promotion as an associate professor with effect from 2020. Next paragraph. During the course of the arguments, the learned counsel for the petitioner has submitted that the primary grievance of the petitioner is the attempted / proposed recovery, and the petitioner would also be the grievance of the petitioner regarding the upgradation or fixation of salary would be redressed in the event this court directs the respondents to correctly fix the salary / pay of the petitioner in accordance with law. Yes. Mr. M. Dutta, learned counsel, appearing for the petitioner, has drawn the attention of this court to the judgment rendered by the Supreme Court in the case of Jagadish Prasad Singh versus State of Bihar and others, reported in AIR 2024, Supreme Court 3950.
Para 23 madam.
Para 20.
Para 23 madam.
The learned counsel for the petitioner has submitted that para 23 of the aforesaid judgment would cover the case of the petitioner to the extent of restraining the respondents from making recoveries, full stop. Para 23 of the aforesaid judgment is quoted herein below or ready referenced. You will find it at this judgment. Huh? Yes, sir. Para 23 to quote.
23 is without recovery with beyond 5 years cannot be made. It also discusses Rafiq Mashi also.
And that is, then they have quoted Rafiq Masi.
Yes,
Para 23, they have quoted Rafiq
yes,
Masi. The learned counsel for the petitioner further submits that fixation of pay of the petitioner would be governed by the relevant law, and therefore the respondents cannot shy away from fixing the pay of the petitioner in accordance with the recommendations of the 6th Pay Commission and the 7th Pay Commission, which have been accepted by the state government. The learned counsel appearing for the for the higher education department, Mr. A.R. Tohbildar, has placed reliance on the judgment of this court rendered in the case of Miss Deep Shikha Das versus State of Assam, decided on 27/7/2017, WPC number 5636 of 2010, to impress upon this court that the appointment of the petitioner being a conditional appointment, he would not have been entitled to draw his salary in the pay scale, and payment of such salary in the pay scale was an error on the part of the respondent authorities. Full stop. He has submitted that as per the judgment rendered in Deepshikha Das within brackets Supra, the petitioner would not be entitled to draw the salary in the pay scale, as at that relevant time the petitioner did not have the net or the SLET qualification and therefore full salary for the underqualified lecturers would be not justified. Full stop. This court in the case of Deepshikha Das Supra had held that the petitioner in that case, who was not having the qualification of net and SLET, was not at par with regular faculty members drawing full salary, and therefore in that case the relief prayed for equal pay to the petitioner was not found to be justified and was accordingly declined. Mr. A.R. Tohbildar, learned counsel for the director of for the Department of Higher Education, submitted that when the petitioner was not entitled to such pay, the excess payment made can be recovered by the department in accordance with law. Full stop. Having considered the submissions of the learned counsel for the petitioner and the respondent, and having also considered the case law cited at the bar, this court finds that the appointment letter of the petitioner did not contain the condition that he would be drawing the minimum of the pay scale which had been granted to other lecturers appointed and who had the qualification of net and SLET. Full stop. The grant of the pay scale to the petitioner was not in the hands of the petitioner at the relevant point of time, and although in the writ petition there is a statement that it has been done solely by the strike out that words although agote end eta koisu nohoy, end to kati diok, full stop korok, although to kati diok. It has been stated in the writ petition that you had shown us one sentence, 19, that that even though in the order of the DHE Assam, there was a mention that the petitioner would be entitled to the scale of pay on fulfillment of the condition of obtaining NET SLET, comma, the order of the principal did not reflect any such condition, and the college authorities had fixed the pay to the petitioner, and the same was continued for a period of over
But the
how many years?
12
No,
without
no,
the
no,
term.
2021.
Yes, sir. So it's 21
They
years.
tried to recover it from 2021.
2020.
From 12 we have given the pay scale.
You gave him the pay scale from 2000 to 2021 initially. Then in 2021, you said that he will be entitled from 2012. Is it not? When did you say he would be entitled from 2012?
The condition
No, condition video is something else,
page
Miller.
28.
In the letter, Miller, which they've
Page
given,
20.
Miller, that is that, Miller.
Page 28 allowed. Page 28.
In 2019.
Yes.
And the same was continued in the same shape till the year 2019, when the conditions in the approval requiring the petitioner to obtain net or SLET to be entitled to the regular pay scale had been withdrawn.
I did not see that 2019 letter. We had allowed the $2 pay scale from 2012 itself.
Then where is what have you withdrawn? Condition.
Condition has been withdrawn. and
What did I say? I said that the condition on the approval was withdrawn.
allowed from 2010. Yes, Lord.
I said the condition on the approval was withdrawn
On 2010. Yes.
in 2019, till which time you continued to pay the said salary. You continued till 2019 at least. You continued it. By the aforesaid letter dated 2011-2019, the petitioner was held to be entitled to the UGC scale of pay with other allowances with effect from 23 to 2012. Full stop. The issue regarding the excess payment and the proposed recovery was brought up by the respondent authorities in the year 2020. Full stop. At this stage, it is necessary to notice that by the judgment passed by the apex court in the case of State of Punjab and others versus Rafiq Masih within bracket whitewasher and others, reported in 2015 4 SCC 334, the apex court had held that recovery from employees when excess payment had been made for a period in excess of 5 years before the order of recovery is issued would be one of the instances where the recovery would be impermissible in law. Full stop. In the present case, the petitioner had been paid in excess of what he should have drawn for a period of more than 20 years, nearly 20 years. From 2000 you were paid
Yes.
for a period of nearly the it is also noticed that in the case of Thomas Daniel versus State of Kerala and others, reported in AIR 2022, Supreme Court 2153, the apex court had held that the state cannot recover excess amount paid to an employee after a delay of 10 years. Full stop. Going by the settled law, this court is of the considered opinion that the excess amount already paid to the petitioner for a period of over 20 years is now cannot now be permitted to be recovered from the petitioner by putting him at, what's that sentence? By putting him in an iniquitous or and harsh situation. Full stop. In such circumstances, the respondents are directed not to initiate the recovery proceedings proposed by huh?
PM 31 directive.
Page 31.
30 and 31.
No, 31 said they asked a clarification from the principal. We are not going to that.
30.
By the order dated, by the communication dated 6/8/2021, stop. Next paragraph. Coming to the question of the fixation of the pay of the petitioner in the correct scale, comma, this court is of the opinion that the petitioner would have been entitled to the payment of salary in the pay scale only from 23 to 2012, and therefore this court cannot, under this court, leaves the liberty to the respondent authorities to fix the pay of the petitioner at the correct scale in accordance with law. Full stop. However, before fixing such pay of the petitioner, comma, it would be prudent on the part of the respondent authorities to give notice to the petitioner of the proposed fixation. Full stop. Since such fixation may vary the pay of the petitioner to his disadvantage. Full stop. Accordingly, this writ petition is disposed of by granting the prayers of the petitioner to the extent that the respondents would be restrained from making any recovery of alleged excess of pay as proposed by the order dated 6/8/2021, and leaving the respondents the liberty to fix the pay of the petitioner at the correct scale. Writ petition disposed of. I think you can pay some costs. No costs.
Entire exercise may be completed till period.
The fixation of the pay of the petitioner, if taken up by the respondents, shall be completed within a period of 4 months from the date of receipt of a certified copy of this order.
He's retiring September 2027.
Now it is March.
So September 2027.
27, 4 months, good enough. We'll make the required changes. We may have repeated a few lines or something. We'll make the changes. Disposed of. Ah, did you? You can take back your judgment. Oh, you'll require to say it. File too.
So in this case, the petitioner, my lord, he retired from service on 31/7/2022, my lord. This pension and pension benefit has not been released, my lord. So, my lord, he has approached this honorable court for his, my lord, pensionary benefit and, my lord, pension, my lord.
Provisional pension?
Yes, my lord. Now, my lord.
Provisional he is drawing?
Paid, my lord. Before that. So, my lord, before that, my lord, I'll take your lordship to order of 7/8.
Lordship, may kindly see the order with 7/8, Lord. Last line, Lord.
7/8.
Last line, paragraph 14, Lord.
Okay. Hmm.
So, my lord,
Just a minute.
That is one aspect, Lordship.
Just
Second,
Mr. Krishnan is almost misery. Provision of pension will affect from the date subsequent to the date from when he had proceeded on the will also be entitled to passing present matter. This matter will not be treated as. Yes.
my lord has read from para 7, my lord.
Ah.
From para 7 to para 7, 8, 9, and 11, my lord. So in that para, in this, my lord, already the case of the petition has been demonstrated, my lord. So, my lord, what has happened, my lord? Now, pursuant to this, my lord, I will just read para 7, my lord, onwards, once, my lord.
No, well, we have read that.
Yes, my lord. So two query has been made by this honorable court, my lord. In para 8, my lord. So para 8, it says the said aspect of the matter would be considered on the next date of listing upon the learned counsel for the parties bringing on record the material to demonstrate the qualification required to be possessed by a person to hold the post of power from operator as on 1986, and also the qualification required for pursuing an ITI course. Pursuant thereto, my lord, two affidavits we have also filed and they have also filed, my lord. So I will take your lordship to that affidavit, my lord. And prior to that, my lord, I will take your lordship to the order of at page 35, my lord. Once more, page 35 of the petition, my lord. Because, my lord, the petitioner, my lord, his initial entry was power from operator, my lord. And thereafter, my lord, his service has been regularized, my lord. And since, my lord, instead of electrician, my lord, his service has been regularized to the post of, my lord, this inadvertently to the post of power from operator, my lord. He has approached this honorable court, my lord, in the year 2013, my lord. And thereafter, my lord, at page 35, may kindly lordship may come, page 35. Page 35, my lord. Of the repetition, my lord. So I will read, my lord, the order that to some paragraphs, my lord. Para number 2, 4, 5, and 7, my lord. Para 2 says, my lord, this entire order judgment has been delivered on who has produced the records, on perusal of the records, my lord. And para 4, my lord, in WPC number so and so, prayer is made for a direction respond to modify the designation of the petitioner from power from operator to electricians, whereas there was two repetitions. 4504-2014 challenge has been made to the legality and validity of the order passed by the disciplinary authority imposing penalty for recovery of excess salary allegedly drawn by the petitioner as electrician for the period so and so amounting to rupees so and so. And by the order of 13/3/10/1991 issued by the Executive Engineer Electrical Division, petitioner was appointed as the electrician in the time scale of the office of the time scale in the office of the Assistant Executive Engineer Lakhimpur with effect from 1/10/1991. At this stage, the petitioner was working as a work-shares power pump operator. And thereafter, para 7, Government of Assam took a decisions in the year 1987 to regularize the service of 1186 work-shares persons who had completed 5 years of service as on so and so. Accordingly, the service of the petitioner was regularized by government order dated 28/2/1997 with the concurrence of the Finance Department. Petitioner continued to work as electrician, drawing his salary in the pay scale of electrician with admissible increments. His service was also opened as electricians. So, my lord, the operative part, my lord, at page at para 26, my lord. Why I'm reading this order, my lord? Because, my lord, in the affidavit, my lord, they have mistakenly, my lord, they have make a statement, my lord, regarding the illegal entry of the petitioner in the service, my lord. That was the allegations they have raised, my lord, in their petition. So I'm reading, my lord, because this order was delivered, my lord, on 29/9/2015, my lord. And my lord, may kindly come to page 43, my lord. What is the operative part, my lord? Page 43, para 26, 2 paragraph, my lord. For all the aforesaid reason, impending penalty is hereby set aside and quashed. Respondents are directed to treat the petitioner as electrician and allow him to continue his service in such capacity with consequential benefit. At this stage, so and so, Learned Counsel for the Irrigation Department submit that liberty may be given to the department to utilize the service of the petitioner in any other capacity if the exigencies of the service requires. While it is needless to comment upon such submission, it is however made clear that in the event such a course of action is contemplated, then while doing so, it should be borne in mind that the petitioner's substantive posting is electrician, my lord. So apparently, my lord, the petitioner was told to be an electrician, my lord. So, my lord, the service of the petitioner has been regularized, my lord. This order has attained finality, my lord. Now, my lord, what has happened? Just 2 months before his retirement, my lord, on the month of May at page 49, my lord, the petitioner was promoted, my lord, to the post of junior engineer, my lord. So now the question arises, my lord, by the way of affidavit, my lord, that whether the admittedly, my lord, the petitioner, my lord, he read up to class 10, my lord. Now, whether a junior, whether the persons who read up to class 10 can be appointed as a junior engineer. Now the junior engineer, my lord, because the service rule says, my lord, that he should be metric standard. He is essential qualification should be metric standard, and he should be an electrician, my lord. From that, one is a feeder post. Thereafter, he can be promoted to the post of junior engineer, my lord. So, my lord, the selections board, my lord, recommended, my lord, me to, has recommended me, and I've been promoted, my lord. Thereafter, I was promoted to the post of junior engineer, my lord. So, on this issue, my lord, as your lordship has seen in the last order, my lord, 2 query has been made, my lord, by this honorable court at para 8, which I have read, my lord, regarding affidavits to be filed by both the parties, my lord. So I have filed 2 affidavits. We have also filed, the state authorities have also filed, my lord. So now, my lord, I will take your lordship the affidavit filed by the state, my lord. At page 184, my lord, the running page at 184. Running page 184, my lord. Take your lordship to page 1.
Just a minute, just a minute.
Yes, ma'am. The affidavit filed by the state, my lord, pursuant to the order, my lord, of 17/9/25, my lord, 17/7/8/2025, my lord. But you may kindly come to para 3, my lord, at page 184, running 184.
Page
184, my lord.
184. By Dhrubajyoti Roy Chaudhary.
Yeah, yes, my lord. Para 3, my lord. I will read para 3, my lord. The unsigned deponent herein begs to state that the Honorable Gauhati High Court in its order dated 7/8/25 passed in WPC, that is, the instant writ petition has passed that the instant writ petition had passed a direction to the Irrigation Department to release the provisional pension and other retirement benefit of the petitioner with effect from the date subsequent to the date from when he was processed on superannuation, that is 1/8/2022. On 17/9/25, when the instant matter has came up for its consideration, it is observed by the Honorable Court that the said provisional pension and other retirement benefit of the petitioner has not been released yet. As such, the Honorable Court was pleased to release the matter again on 19/9/2025 by directing the Irrigation Department to release the provisional pension and other retirement benefit of the petitioner latest by 19/9/2025. And in the event the same is not released, the council representing the Irrigation Department was directed to place instructions before the Honorable Court as regard the reasons as to why the provisional pensions and other retirement benefit of the petitioner has not been released till date on the next date of hearing of the case on 19/9/2025. Accordingly, the instant additional affidavit is being filed by the Chief Engineer Irrigation Department, that is the deponent herein, stating the reason as to why the provisional pension and
Ah.
other retirement benefit.
Read.
Yes, my lord. So thereafter, my lord, the next paragraph, my lord, your lordship was read.
Mhm.
So, my lord, prior to my lord, 21 to 91, there was no specific book because the petitioner, my lord, he was appointed in the year 1986, my lord, and the rules came in force in 1991.
Your appointment is not wrong.
Yes, my lord. So, my lord,
Your posting as a electrician has been upheld by this court.
yes,
Too much of water has flown.
yes, my lord.
But now, whether you could be promoted to the post of junior
Yes,
engineer or not, and whether your pension has to be fixed in the post of a
Uh,
electrician
or
or a junior engineer. That is the
that
code of
is the
law.
earlier.
And that is why lordship in page 186, we have
How we have,
stated,
I've seen that.
once it is
Once it is cancelled, he will be entitled to the
provisional
pension of
pension,
a.
electrician.
Why don't you pay him that for the time?
Lordship, that is what I am submitting, Lordship. This is not a fixed matter, Lordship. All of a sudden, the matter got listed and I am appearing, Lordship. So if Lordship is taking up this matter, Lordship will grant me some time, Lordship, at least 1 week time. In the meantime, I will
because
complete my instruction.
If you now, because once you have not obeyed the order of the court for a long, long time, there were several orders in between. After that order of 7/1,
I think,
Yes,
2025 or
thereafter,
something.
Lordship, matter was not taken by any other court, Lord.
It was,
Only
it just
on the
came up on
pointed
a,
out that
on a
it's a
piecemeal
part-time.
basis, one liner orders, but it was not complied with. What order was passed on that part has not been complied with. Complying would not mean,
The order has
The-
been complied. Court directed to give
Why not- why not paid?
instruction of why not paid, Lordship. And the reason has been given. It has already been requested the authority to cancel his promotion.
now, whether you cancel his promotion or not, he will be entitled to the provisional pension of at least the electrician.
That is there.
That even if that is released, survival is there.
Lordship,
Once
and
survival is there, the fight will be stronger.
I have no objection, Lordship. To that extent, Lordship, I have no. So far as
What do you say?
provisional pension as per electrician, Lordship, I am
Provisional pension and the DCRG as per electrician.
yes.
As per electrician,
that
you release
extent
it
it is
for the time being. Would that help you? Because that is that is minimum what you will get. You win the writ petition, you get it for the junior engineer. Otherwise, if the promotion is cancelled, till the time you get.
But, my lord, one thing I'm submitting.
Ah,
The entire issue boils down to the one word, my lord, metric standard. If the qualification requires metric standard, means,
Today-
my lord, metric pass, my lord, definitely, my lord, I cannot be promoted because I read up to class 10, but I am not metric pass, my lord.
so
So if that is so, my lord, then, my lord, if the rule says metric standard, according to me, what I have searched, my lord, I find, my lord, metric standard means somebody read up to class 10.
up to.
Up to, my lord, up to, my lord. What I have searched, but I don't find an exact judgment to that effect, my lord. Because wherever I find out, my lord, you might make a comparison search of metric standard and metric pass, my lord. Everywhere it comes that metric pass means it attends.
He read up to 8 standard.
That is
So
not-
he reads up to
issue
class
is-
8.
The issue is not that, Lordship. Issue is different. If Lordship comes to page 50,
The certificates are.
he submitted HSLC pass certificate.
I'm not passed,
That
my
is the difficulty.
No, you have submitted it, but
lord. My lord.
you have not submitted. Oh, that.
No, he was asked,
My lord.
he was
Yeah.
asked, then it,
My entire petition, my lord, in my entire petition, I have stated, my lord, I read up to class 10, my lord. I read
No,
up
in
to
the
pass.
petition you have.
petition you can state, Lord.
In the petition
Prior
you
to that.
stated. Have you contested this letter?
Yes, my lord.
He challenged this.
I have challenged this letter.
No, no, this letter.
Yes, letter of my lord. Letter of this
Page
page 58, my lord. What they say, my lord? Page 58, my lord.
Yes, we are trying to reach it.
Fine.
This letter.
Yes, my lord. What they say, my lord? His age is shown in while verification of
The
his
undersigned directed him to produce his original HSLC pass certificate. Accordingly, he produced the original certificate. Are you denying it?
Yes, my lord. Definitely, I'm denying, my lord.
You are saying that you have not produced that certificate.
My lord, what he says, my lord, while verification of the service book and pay fixation, the following observation has been made. His age was recorded, enclosed, and the true copy of the HSS certificate enclosed with the service book. It is there in the service book. Service book is in custody of the respondent, my lord. How I can, my lord, document not recording of the date of, my lord, regarding my HSSC pass in the service book, my lord. They simply say that, my lord, The service book, in the service book, one document is enclosed. Who put this document, my lord? Because I am not the custodian of the service book, my lord.
One is HSLC, I mean the education qualification, and the next one is date of birth. Lord, if lordship comes to.
No, it is the same same HSLC certificate. One records his date of birth has
17 years,
17 years and the other
16 years.
16 years, 8 months. Now he's already retired. He did not have a show cause notice.
I have still time, lordship, till 24, 26, 4 years lordship I have, even after retirement. That was observed, I think, in the last order, lordship. Probably, most probably, if I remember correctly.
No, for an incident which happened. What a second. Pension. 22 niki?
Event 4 years.
What was it, 22 or 21?
21 B2, my lord.
It will be with the sanction of the governor only.
Yes.
It will be with the sanction of the governor.
An event more than 4 years.
That instruction also I do not have, lordship. But if lordship comes to paragraph 12, lordship, so lordship, they can definitely modify this.
But then, any event which took place more than 4 years before such institution, the submission, when did they allege that you submitted it? The second, the one that you have challenged, page 58,
My lord,
22,
22, my lord.
22, lord.
22. So till July 26, you are at
But my lord,
risk.
this, my lord,
Thereafter, lordship, I cannot take any action against him. So in that situation.
So now, today we will observe whatever has come on record.
No, if lordship looks at paragraph 12, lordship, of
Of?
the earlier terms. My lord justice has ordered, lordship. Paragraph 12, it is provided that the directions passed herein above for release of petitioner his provisional pension and other pensionary benefits would be subject to further orders that would be passed in the present matter.
No, what
So
we,
I have filed my affidavit, lordship. Lordship
so
has
now
not
what
in the-
today we will observe is,
Yes,
case will require some hearing.
yes.
Provisional pension cannot be denied since as of today there is no DP. Without prejudice to the petitioner or the respondents.
Lordship, whether
Since
there
the
is-
minimum provisional pension that he would be entitled to at this stage is that of a
at least of
electrician, you would take steps to release the provisional pension to him.
my only submission will be lordship will not record that the no DP is. has
Now,
not
as of
been
today,
Lordship, that instruction I do not have, lordship. If in the meantime they have initiated, lordship, that.
even if it is initiated that, acha. Okay, that we can do.
Lordship has seen the reason. It page 186, I have given the reason why his provisional pension has not yet been released.
Ah.
Lordship will take.
No, we will read that to be
Reason.
provisional pension in the post of, with respect to the post of junior engineer cannot be released.
My submission will be, even if his promotion is cancelled, he will be entitled to promotion for the post of electrician.
Huh.
So at least for the post of electrician, he may be released.
He will-
provisional pension. Authority will decide his releasing the other payment, lordship, after decision.
That is what minimum you would get. Start with the minimum. Heard Mr. G. Alam, Learned Counsel, appearing for the petitioner. Also heard Mr. P. Nayak,
I'm appearing for irrigation department.
Learned Additional Advocate General, appearing for the irrigation department. Good stuff. The additional affidavits is required to be filed by the order dated 7/8/2025 have been filed. Full stop. On perusing the same, this court is of the opinion that the matter would require extensive hearing. Full stop. Mr. G. Alam, Learned Counsel, appearing for the petitioner, has submitted that the petitioner has not yet been paid any retirement benefits, although he retired in the year 2022. Stop. This court, by the order dated 7/8/2025, had directed the provisional pension and the DCRG to be paid to the petitioner. And in case the same was not paid, comma, where was that?
Malot, 11, Malot.
No, where were you given that
11,
if you don't pay, then you give the affidavit or you give the cause? I do not find that sentence, sir.
The paragraph 12 is there, Lordship. That provision for modification has been kept.
But you're not paying it is not.
No, Lordship is aware that why I am not paying.
That we are aware, but that is why we said that even paying it on that rate and telling us would have been compliance. But here, this is a case of total non-compliance.
No, yes, Lordship.
Although he has not agitated the issue and we are not taking it up in that line, but this appears to be a
Yes, but I am
simple non-compliance.
saying, Lordship, paragraph 12 is there, and Lordship, there is a
What did we say? Had directed the respondent authorities to release to the petitioner his provisional pension with effect from the date subsequent to the date from when he had proceeded on superannuation, that is with effect from 1/8/2022. Full stop. The petitioner was also required to be paid the DCRG and the other pensionary benefits, including leave, encashment, etc., within a period of 1 month from 7/8/2025. Full stop. This court notices that till date, no payment has been made by the respondent authorities, and this court expresses displeasure on the same. Full stop. On considering the submissions, this court has also considered the submissions of the learned additional advocate general that that in the event the petitioner was found to be a non-matriculate, his promotion to the post of junior engineer would require an interference and a reversion, and therefore the respondents have not released the pensionary and other benefits to the petitioner in the post of a junior engineer. Full stop. This court is of the opinion that even in such an event, there was no impediment on the part of the respondent authorities to have released the provisional pension, DCRG and leave encashment benefits to the petitioner, at least deeming him to have retired from the post of the electrician, subject to the outcome of the petition. Full stop. This court is also of the opinion that even in the event the promotion of the petition is cancelled, that is what the minimum that the petitioner would be entitled to on his retirement from service. Full stop. Accordingly, it is directed that the respondent authorities would release the provisional pension along with arrears and the DCRG benefit along with other other permissible pensionary benefits, including leave encashment, to the petitioner by
Lordship, provisional pension we will release within 4 weeks, Lordship. Others may take some time, Lordship. Lordship will fix date for, fix time for provisional pension. For
what we will do is we will have everything given in this order. We'll ask you to give everything in this order. Fix it in the month of April.
Lordship.
By that time, you come and let us know.
Lordship.
The
Provisional
time,
pension is
the
possible.
next date will be fixed more than more than a month hereafter, allowing you that time in which you can act. You will have 6 to 7 weeks to work on it.
Lordship. Lordship.
We will not
Provisional
fix it
pension, no issue,
immediately
Lordship.
on the
We can-
30th
We
day.
can provisional pension, we can release within 4
Ah.
weeks, Lordship. DCRG and LE will take some
For
time.
DCRT, they have to send a
Proposal to the
proposal
AG.
to the accountant general. Lordship.
See, it was always done in the earlier order.
But till that, they are achieving that they are not following the document.
Ah. So we are asking them to do it.
Lordship.
Even if they come on the next day and say that the DCRG is in process and it is with you.
Yes, Lordship.
Seldom is the case that we take it harshly.
Yes.
Is it not? Once people work, we don't take it harshly. By deeming the petitioner to have retired from the post of, no, at the same rate that the petitioner would have been entitled to had he retired from the post of an electrician. Full stop. This court makes it clear that it is not of the opinion that the petitioner ought to have retired from the post of an electrician, but it is only to grant an interim relief to the petitioner without prejudicing the case of either the petitioner or the respondents that the above directions have been passed. Full stop. List this matter again. No, list this matter for hearing on. We'll have it on the 30th of April.
Lordship.
On the 30th of April, 2026. Full stop.
Lordship,
It
let
has been
be on
submitted.
31st, Lordship. It will be
on
on
the-
Tuesday, Lordship.
No, we were on April.
Oh, sorry.
We don't have a 31st.
Lordship. I'm sorry, Lordship.
30 April is fine.
Lordship.
30th of April, full stop. The learned additional advocate general has submitted that payment of the DCRG may require a processing through the office of the accountant general also. Full stop. However, the payments which are at the hands of the irrigation department would be processed with due would be processed at the earliest. Full stop. List as or list on 30th as directed. Release that much to him.
Lordship.
Let him
Provisional
survive.
pension will be released. Provisional pension. Obliged not to be released.
I'll just come back. 2 minutes.
Promotion was held up.
Huh.
Ultimately, your lordship will find that your lordship that finally they have decided to promote me, your lordship.
Huh.
And before that, your lordship will kindly come to page 41. This is the gradation list, your lordship. Page 41. Promotion was due, but promotion was held up due to violation of the punctuality of office attendance, and the matter of promotion was placed before the board meeting approvals. He was also granted early so and so, your lordship. Then, your lordship, I was representing, and then finally, your lordship, they have decided to promote me, but that your lordship will get at their affidavit, your lordship, affidavit filed by the authority, your lordship, board. Respondent number 3, your lordship. Page 65, your lordship. It was dated 11/4/2023. Your lordship will kindly come to page 65. It starts from page 65, 66. This was the issue, your lordship. Page 66, your lordship. Fourthly, the managing director placed the name of following junior assistant along with eligibility.
Yes.
Lordship.
Remember.
Lordship.
Where is that rule?
Rule, your lordship has that, but I have one copy. Now they say that they have forwarded it to the government, your lordship, since in the meanwhile, the post of junior, for the eligibility, educational qualification for the post of junior assistant has.
That for recruitment it is required, and for promotion it is not required or not. That is what we had last time. We had a discussion with Mr. Dhar, and then although the Social Justice Department had been implemented as a party. Since the name was not shown, Mr. Das was not here, and today after the name is being shown on the first call, we are told that he is attending some matter in other court, and now we are told that due to inconvenience, he is not in court. This we are going to record in the order, these two aspects, and therefore we are going to decide it in the absence of Mr. R. M. Das.
My lord, my submission is
Yes,
page 68.
68, yes.
68, my lord.
Yes,
After, my lord, the board, my lord, has taken a decision.
Hmm.
We could not promote her.
Hmm.
So that is why we have sent it to the department, my lord.
Hmm.
So we haven't received anything from the department.
you have not received a
Many, any instructions, my lord.
from 2023.
23, my lord.
From 2023, you have not received any instruction. This also we will record. And if you want, we will impose some cost on the department also for not cooperating with the disposal of writ petitions. This issue is being taken up time and again that the cases are pending in the court. So we'll see what we can do about it. We'll try to shift, not shift the burden, but we'll try to put up the actual cause why cases are not being disposed.
We exactly did not deny the promotion.
Huh.
We have sent it to the government for approval.
Huh.
That is one.
We'll
is
see
what-
that the
that is
approval
my-
comes from this court.
Affidavit says.
Yes, sir.
Lordship, Rule 13 is the promotion, your lordship. It says your lordship will kindly come to junior assistant come typist to senior assistant, Rule 13, Roman 7, your lordship.
Heard Mr. S. Botakul and counsel appearing for the petitioner. Also heard Mr. R. Dhar, learned additional senior government advocate
Corporation.
appearing for the Assam State Development Corporation for Scheduled Caste Limited. Full stop. Pursuant to the order dated. Where is that order allowing you to file that to implead the party?
Lordship, it was ordered dated 13 to
13 to 20.
26.
Pursuant to the order dated 13 to 2026, this court had allowed the Secretary to the Government of Assam, Social Justice and Empowerment Department to be implemented as a party since the learned additional senior government advocate had clarified that the concerned department for the present matter is the Department of Social Justice and Empowerment. Full stop. Accordingly, on the 20th of February 2026, an amended cost title had been filed, and by the order dated 9/3/2026, this court had required the matter to be listed today, showing the name of Mr. R. M. Das, Learned Standing Counsel for Social Justice and Empowerment Department in the admission column as a part heard matter. Full stop. On the first call in the morning, this court was informed that Mr. R. M. Das is attending a matter in another court and therefore the matter may be taken up after some time. However, on the second call, an associate of Mr. R. M. Das has informed this court that Mr. Das is not present in the court due to some personal inconvenience. The court does not appreciate the manner in which the matter was requested to be passed over at the first instance by stating that the learned counsel appearing for the department was on his legs in another court. Full stop. Since the matter had been heard in part on earlier occasions, and the affidavit on behalf of the
Number 3. Your
respondent number 3, that is the Managing Director, Assam State Development Corporation for Scheduled Caste Limited, is already on record, comma. This court is taking up this matter for disposal. Full stop. The facts leading to the institution of this writ petition under Article 226 of the Constitution of India is that the petitioner had been appointed as had been appointed as a junior assistant cum typist in the office of the Managing Director, Assam State Development Corporation for Scheduled Castes Limited, and when there was some and pursuant to the orders passed by this court in Civil Rule number 1636 of 1996, comma, the Managing Director of the corporation had allowed the petitioner to continue in her service as junior assistant as ordered by the original order dated 30/12/1995. Full stop. By an order dated 13th of April 1999, the services of the petitioner had been regularized in the cadre of junior assistant cum typist in the office of the corporation. Full stop. When the petitioner was denied her promotions, comma, the she had made representations for being considered for promotion to the post of, yes, what is that post?
Lord, senior assistant, Your Lord.
Huh?
Senior assistant.
Senior assistant, full stop, due to certain alleged unauthorized leave availed by the petitioner, comma, she had been. Who is this Bhavendra Chandra Das?
Your Lordship, page 41.
Huh?
For page 41. The gradation list, Your Lordship, where
No. You were given some show or some disciplinary action?
that's
That is what we were asking.
so, Your Lordship,
What did we say that sentence that a certain period of her absence from duty had later been regularized as commuted leave on average pay on medical grounds. Full stop. Thereafter, just a minute. By an order dated 16th of January 2021, the petitioner had been transferred from the Mongoloi branch to head office with immediate effect. Full stop. By an order dated 4th of March 2022, another set of alleged unauthorized absence of the petitioner had been regularized by granting her earned leave. Full stop. The petitioner was thereafter provided a provisional gradation list where her name reflected at serial number 2. With a remark that although the promotion of the petitioner was due, but it was held up due to violation of punctuality in office attendance, and the matter was placed before the board for approval She was granted earned leave during the absence of a period of absence. Full stop. By no, during a meeting of the board of directors of the corporation held on 9th of June 2023, comma, the case of the petitioner had been taken up for consideration for granting her promotions. Where is that?
That is your page
Agenda?
66, page 66, in the affidavit of the,
No, what is this?
this, your lordship, they have not considered, that is what I have.
Where is it?
Your lordship will
My
kindly
lord-
come to page 66.
No, page 40, page 46. Why is page 46 on record?
Lordship, these are the board meeting, your lordship, where her case has not been considered.
Ah, then you strike up that sentence. The case of the petitioner was not taken up in the meeting of the board of directors held on Friday, the 9th of June 2023 for promotion. Full stop. Aggrieved. The petitioner moved this petition. Full stop. The affidavit in opposition of the filed by the corporation has brought on record
It starts from 65, page 65.
has brought on record the minutes of the selection committee meeting held on 11/4/2023, where the case of the petitioner had been taken up for consideration for promotion to the post of junior assistant, and it reflects that the managing director of the corporation had informed the board that as per notification issued by the government of Assam recently, comma, the requirement for recruitment to the post of junior assistant, comma, the qualification of graduation had been made mandatory. The resolution thereafter records that although the petitioner and another junior assistant could not be considered, no, sorry, on the minutes of the board, the minutes of the meeting thereafter, the resolution of the meeting thereafter record that though the petitioner and another junior assistant possess the qualification of HS passed when they were recruited to the post of junior assistant prior to the issuance of the government notification, comma, they were not graduates. Full stop. The members of the committee that thereafter decided to forward the matter of promotion of the two persons, including the petitioner, to the government for consideration for approval. Full stop. The affidavit in opposition further reflects that the managing director had sent a letter to the joint secretary of the government of Assam, Social Justice and Empowerment Department, on 24th of May 2023, giving the vacancy position, and by referring to the acute shortage of manpower, comma, the board of directors had decided to promote all eligible employees to the next post. Full stop. Mr. Bodhakur, learned counsel appearing for the petitioner, has referred to the service rule of the officers and employees of the Assam State Development Corporation for Scheduled Caste Limited, comma, 2005, to submit that the promotions from the post of junior assistant to senior assistant are governed by the provisions of Rule 13 of the Rule 13, full stop. According to Mr. Bodhakur, comma, where does it say about that 15 years or what? No.
Lordship, that is the, your lordship. 15, your lordship, rule 15.
At Rule 15, the qualifications. Mhm. Are given at the qualifications for a particular post is given at Rule 15. Full stop. The where do you say it has become graduate?
Lordship, there,
It is in 10,
rule 10, it
Rule 10, 10A.
PU is pre-university.
pre-university, your lordship.
HS is higher secondary or graduate. Where did you find this only graduate part?
10, my lord, 10A.
Please read it.
Assistant development officer.
He is not an assistant development officer.
I am for a senior assistant.
He is
For the post of assistant development officer, my lord. Now, my lord will come to the next page, my lord. 13(6). Junior assistant, recovery assistant to ADO. So, my lord, this and senior assistant, these are all same grade, my lord. Grade,
But for senior assistant, it is not there.
here it is there, my lord. It is senior assistant, my lord. 13(6).
Oh, you show us in 10.
Slash.
You show us in 10.
That will have to be there in 10.
See, again, let us let us again understand it. Number 6 of 13,
My lord.
junior assistant oblique recovery assistant.
My lord.
Now please come to 10.
10, my lord.
C,
C.
junior assistant oblique recovery assistant. So they are given as an or.
Yes, my lord.
It both of them exist.
Yes.
Now come to ADO oblique senior assistant. At Rule 10.
Assistant 2.
At where is it assistant 2?
My lord, junior assistant, recovery assistant,
Uh-huh.
2 ADO slash senior assistant.
Exactly. So the senior assistant part is conspicuously missing in Rule 10.
No, my lord, we have to read 10A.
You are making us read too much.
No, my lord. That is what, my lord.
You are making us read too much.
No, my
That
lord.
day also you made us read too much. Now also you are making it. Why should we keep reading into the rules all the time?
My lord, that is how, my lord, if there is, my lord, ambiguity, my lord, my lord has to clarify.
Literal interpretation.
220.
Your lordship, that is the
My lord,
10
my lord, now.
Okay.
This is what, my lord, 10A. 10A says that, my lord, for the post of assistant development officer, he must be graduate with 5 years experience, such and such. Then, my lord, not find anything with regard to the senior assistant. It comes in 13(6) only, my lord.
If it had come in 13(6), if we are to read into Rule 10, then why both junior assistant and recovery assistant are specifically provided for in Rule 10? It was the intent of the rule-making body to keep senior assistant out. That is how we will read it, if we have to read it.
My lord, at that time, my lord, junior assistant, recovery assistant, PU, HS, graduate. 10C. PU, HS, graduate in arts, science and commerce. So, my lord.
For ADO, he must be a graduate.
Graduate. So, my
But
lord,
for senior assistant, it is not there.
Now she is seeking to the higher post. Junior assistant to senior.
Could be, but the senior assistant is not provided for. No qualification required.
My lord.
Anybody a junior assistant can become a senior assistant.
No, my lord. That is why 13.6 comes in. 13.6, it says that, well, how the promotion cadre ballot it is. Junior assistant and recovery assistant, they fall in the same cadre ballot to ADO/senior assistant ballot.
The learned counsel for the petitioner has submitted that insofar as the cases of promotion in the corporation is concerned, the junior assistants and recovery assistants have a scope of promotion to the post of assistant development officer and or senior assistant, full stop. Hmm. The learned counsel for the petitioner has submitted that the rule as it stands today, no specific educational qualification for the post of senior assistant has been depicted, but for the post of assistant development officer, a candidate was required to be a graduate with 5 years experience in service for direct recruitment to such a post. Now we'll tell you why senior assistant is not there. This 10 is for direct recruitment only. Do you see? Senior assistants can never be directly appointed.
Yes, it's a
But
promotion.
an assistant development officer can be directly recruited.
I am only on this, my lord. 13.6.
Huh.
It says, my lord, junior assistant /
Yes, this will take into consideration when we record your submission. We'll take it in. Accordingly, the learned counsel for the petitioner has submitted that when the rules requiring the when the rules do not lay down that that a candidate for the post of for promotion to the post of senior assistant requires to be a graduate, the act of the respondent authorities in not granting the promotion to the petitioner to the post of senior assistant, is not sustainable in law, and the respondents are required to be directed to consider the case of the petitioner on the basis of her merit and, if found suitable, to be promoted to the post of senior assistant forthwith, full stop. Mr. Aadhar, learned additional senior government advocate, has submitted that promotions to the post of ADO/senior assistant are made from the posts of junior assistant and recovery assistant, as is reflected in Rule 13 of the Rules of 2005, full stop. The learned additional senior government advocate has submitted that Rule 10 depicts the requirement of a candidate to be a graduate with 5 years experience in service to be eligible to hold the post of assistant development officer, and since the post of assistant development officer / and senior assistant are kept in the same subclass at Rule 13 within bracket Roman 6, the requirement of the candidate to be a graduate to hold the post of senior assistant is a sine qua non, full stop. The learned additional senior government advocate has submitted that since the petitioner is not a graduate, comma, the corporation had rightly sent the matter to the government for consideration as to whether the petitioner could be afforded her promotion to the post of senior assistant, comma, since she was found eligible and meritorious on the other grounds, save and except the ground of her being required to be a graduate, full stop. The submissions made by the councils for the contesting parties have been duly considered, full stop. Rule 10 of the rules of 2005 and Rule 13 are quoted herein below for ease of adjudication, full stop. Then quote the Rule 10 and Rule 13, huh? Okay, you make it a Rule 10, 13 and 14. Okay. Huh? As this court notices that Rule 10 of the rules of 2005 relate to the academic qualification and experience of candidates for direct recruitment, full stop. In the said rules, for the post of for a candidate to be eligible for direct recruitment to the post of assistant development officer, comma, he is required to be a graduate with 5 years of experience in service. For direct recruitment to the post of junior assistant or recovery assistant, the candidate must be either a pre-university oblique higher secondary or graduate in arts oblique science or commerce, full stop. Rule 10 is conspicuous by the absence of the post of senior assistant. This court is of the opinion that the absence of the post of senior assistant in Rule 10 is a natural corollary of the concept that the post of senior assistant can only be filled up by way of a promotion and not by way of direct recruitment. Full stop. Therefore, Rule 10. Therefore, the academic qualification and experience of candidates required by Rule 10 for direct recruitment to the posts of ADO would not be applicable for consideration of a candidate for promotion to the post of senior assistant, comma, which can only be filled up by way of promotion, full stop. Rule 13, which has been quoted herein above, is specific to the extent that the suitability of a candidate would be decided by the board and by the appointing authority in the manner set forth in Rule 14. And now this you will make bold, huh? Yeah, and in bold letters, subject to possessing qualifications and experience as prescribed herein after. Full stop, bold close. Huh? Thus, this court is again of the considered opinion that the qualification experience prescribed after the Rule 13 would only apply in the cases of promotion, and none of the qualifications or experience prescribed in Rule 10 can be brought into play while considering a candidate for promotion under Rule 13 of the Rules of 2005. Rule 14 of the rules, which have also been quoted herein above, does not lay down a condition that for the post of for promotion to the post of senior assistant, the qualification of graduation would be a necessary qualification, full stop. The court's attention is here and at this stage is drawn to Rule 15 of the Rules of 2005, where the qualifications are again given, comma, which this court has to presume to relate to the promotions to be effected under Rule 13, full stop. In Rule 15 of the rules quote as below. Rule 15 to quote kori dibo. Full stop. In view of the aforesaid discussions, comma, it is obvious to this court that for promotion to the post of senior assistant from the post of junior assistant, comma, a candidate is required to be considered on the basis of merit with due regard to seniority. Full stop. The requirement of possessing the qualification of graduation for junior assistants to be considered for senior assistant does not find place in the rules of 2005. Full stop. True, it may be, as submitted by the learned additional senior government advocate, that for direct recruitment to the post of assistant development officer, comma, a qualification of graduation would be mandatory, but this court is of the considered opinion that the said qualification cannot be held as mandatory for being considered to the post of to be considered for promotion to the post of senior assistant. Full stop. In view of the findings aforesaid, comma, this court holds that the petitioner, being a graduate, is the petitioner who is serving as a junior assistant and has and holds the second position in the gradation list. She holds the second position, sir? Second position in the gradation list is entitled and qualified to be considered for promotion to the post of senior assistant on her turn. In fact, her case has been taken up for consideration and she has been found to be otherwise entitled, save and except the requirement of graduation, which was introduced by the managing director of the corporation as per notification issued by the government of Assam. Full stop. The rules of 2005 having been not amended in accordance in accordance the rules of 2005 not having been amended to include the provisions to include the provision of making graduation a mandatory qualification for consideration to the promotion to the post of senior assistant, comma, the petitioner had been rightly considered for her promotions by the minutes of the selection committee meeting held on 11/4/2023. Full stop. The matter had been forwarded to the Joint Secretary of the Government of Assam Social Justice and Empower Department, Dispur, Gauhati 6 on 24th of May 2023. And as of today, when the matter has been taken up for hearing, there has been no response by the aforesaid department. Full stop. In view of the above, this court directs the respondent number 3 2 take necessary steps to ensure the promotion of the petitioner to the post of senior assistant with effect from the date. With effect from such, any juniors have been promoted?
No.
Huh? To give final effect to the consideration having to give effect to the consideration that had been given by the board of directors in the meeting dated. What is the meeting dated?
65.
11/4/2023. where the petitioner had been, where the matter had been only forwarded to the government for consideration only on the ground that the petitioner did not uh, have the qualification of graduation, full stop. The respondent number 3 shall take immediate steps to have the DPC convened to consider the case of the petitioner for promotion to the post of senior assistant without reference to the qualification of graduation, since such qualification is not required under the rules. Full stop. The final consideration and effect to the minutes of the DPC required to be convened by this order shall be done within a period of 3 months from the date of receipt of a certified copy of this order. Full stop. Writ petition is accordingly disposed of, no costs. Whatever minor changes are required, we'll have to make, because some sentences we are breaking up or repeating. We'll just, the end of the story would be, you consider her case by a proper DPC as required in law without reference to the qualification of graduation, and if found otherwise eligible, to give her the promotion within a period of 3 months from the date of receipt of certified copy.
Deeply observed.
Writ petition disposed of. Yes. Huh?
This is regarding compassionate appointment, my
Huh?
lord. Our case has been recommended by the state level committee for appointment, my lord.
When?
In the year 2023, my lord.
Hmm.
Page number 18, my lord. Annexure
1-8.
1/8, my lord.
Uh,
2/3/2023, my lord.
just a minute. Yes. You are you are R3.
We are 3 petitioners, my lord. Petitioner number, serial number 1 is the petitioner number 3, my lord.
Okay.
Then, my lord.
8 and 9.
8 and
Then?
9. And
Then what happened? They did not appoint you.
no, my lord. No appointment has been made.
Yes, madam. After the recommendation?
Lordship, kindly see the recommendation.
Hmm.
Recommended for appointment against grade 4 post subject to availability of vacancy under 5% quota in other departments as per OM dated so and so. So when they are recommending lordship, they are again putting these things, lordship, this should be another 5% and all this. Anyway, lordship, we have filed affidavit, and the affidavit by the chief secretary, lordship. When the matter was taken up, there was a direction from this honorable court, lordship, and clarifying all this, lordship, it has been filed. Lordship may dispose it of.
But you have said that it is yet to be received. At page 24.
Lordship.
At page 24.
Lordship.
Can we see? I don't know who has filed it, but page 24.
24, I am not aware, lordship.
My lord,
Have you seen this affidavit by
Commissioner.
Commissioner and Secretary to the Irrigation Department?
No, lordship, then the irrigation will justify.
No, you have filed this as the Additional Chief Secretary of the Irrigation Department. That is signed by you.
Lordship, one, this is by the chief secretary, lordship.
And the other one was by the Commissioner and Secretary.
This is in compliance to the order passed by this.
As a
honorable
second
court,
order
lordship.
passed. Okay.
6/1/2025, there was a direction, lordship.
No. This will not work. Your second affidavit will not work. Those cases were required to be reconsidered
Lordship,
by the orders of this court,
lordship.
which were pending. Now, their cases were not pending a consideration. Their cases were awaiting an
Yes.
appointment,
Lordship.
subject to availability of
Lordship,
5%. Just
lordship,
tell
that's
us.
telling lordship, with the affidavit that has been filed by the chief secretary, lordship may dispose it of. Because it is all stated, lordship, here,
What?
in paragraph 5.
What is it stated?
That the deponent further begs to state that the state is dealing with the applications for appointment on compassionate ground in cases where the DLC recommendations were made prior to so and so in the matter as mentioned in Finance Department notification number so and so. Then
Their recommendation is of
accordingly,
2023.
the recommendations of the DLCs in those cases had been placed before the SLC.
That is
for
of
discussion.
2017, madam.
Lordship. But
His
in
recommendation,
Lordship, those whose cases are there,
his recommendation is of 2023.
Lordship.
Recommendation has come. Should it again go before the SLC?
This,
Cannot.
because this one is their lordship,
Which-
subject to availability of 5% and all
So
this.
just
lordship.
tell us whether, now if you have the earlier affidavit, kindly have the earlier affidavit.
1 minute, Lord.
Do you have a copy? Give her a copy.
1 minute.
It is by some Dhrubajyoti Roy Chaudhary, if you can find. Do you have that? Now, kindly have paragraph 6.
Lordship, this, they can, the department can.
Same department, you are the
Same
department.
department, mine is by chief secretary, Lordship.
And who is this
They have separate.
commissioner and secretary?
Separate standing, Ravi Kota is the chief secretary.
Kindly
Lordship.
have the affidavit which was given to you. Who has signed it? Kindly see. Who has signed it?
This is Dhrubajyoti Rai Chaudhary.
Paragraph 1.
Presently upon holding the post of the under secretary.
To the,
Government of Assam Irrigation Department.
and you are saying that you are the chief secretary to the government, additional chief secretary of the government of Assam Irrigation Department.
No, Lordship.
Then your cost title is wrong. Look at the cost title.
Oh, Lord.
That is why I am confused. We go by shortcuts.
Lordship. No, actually,
Eh?
it was there. First, it was prepared on behalf of the chief secretary. Then he was out of station. So hurriedly, we put this one, Lordship. Later on.
So
he
therefore,
told me-
when I see irrigation department at the cost title,
Lordship, yes, Lordship.
I'm assuming both are by the same
Lordship.
department. Yes, irrigation.
Because this has been signed and they have not seen this.
Yes,
Lordship.
irrigation.
That's the first of
You are paying for irrigation.
Department, my
Eh?
lord. Yes, Your Honor.
In 2023, you told this court, sir, we are awaiting the vacancy position.
Yes, my lord. Thereafter, my lord, this
Too much of waiting. Huh?
the notification has been suspended, my lord. That's why, as per as the notification has been suspended by
Which notification?
so OM compensation appointment notification, OM.
You have already recommended. You are awaiting the vacancy position. What was suspended?
My lord,
That one with the where then the less than 3 years remaining service, 1 year remaining service, that was suspended. Their cases have been considered by the other earlier.
my lord, as kindly have a look at
Tell us.
order dated 27/6/2023, my lord. Have a look at order dated 27/6/2023.
23 years.
My lord, at last,
27/6/23, I don't have any order.
27/6.
Or 27/6/23, yes. Huh.
At last para, my lord, it is
Yes.
stated that as Mr. Penal Line Standing Council Finance Department appearing for the respondent submits that the case of the petitioner was not wrote through the district level committee, but was directly placed before SLC. As a result of the which the recommendation has been made without asserting the vacancy positions in other departments, my lord. So, my lord,
So, now do you have your affidavit with you? You have filed an affidavit on November 2023. Do you have it with you, madam?
yes, my lord,
Please come to page
is 38.
38.
Yes,
Do you have page 38 with you?
yes, Your Honor.
What does it say?
The vacancy position is not yet, the commission availability of vacancy within 5% employment quota of the cadre strength is not available, which is department at present, my lord.
So when will you have it?
I will take instructions in this regard.
What instructions? They will say we have not received it.
We have not received it yet.
Yes, Madam Chief Secretary, appearing from Chief Secretary. In view of the orders,
His Lordship kindly ignored this cost title part.
no, we are ignoring it. No issues. The recommendation which had been made,
Yes, Lordship.
that it should be done subject to availability of
Availability
vacancy.
of the-
The affidavit filed by the department, that
Lordship.
they are awaiting to forward it to the appropriate department once the vacancy position is known. We will dispose of this repetition,
Lordship.
directing the Chief Secretary to forward this, to call for the vacancy position,
Yes,
that 5% vacancy position from the different departments, and either appoint or tell the petitioners that the 5% vacancy is not
Lordship.
available, we are sorry.
Yes, Lordship. This way actually all the matters are being taken care.
That is to be done. Only if there is a vacancy, you will be appointed.
My lord.
Is it not? So we'll direct the Chief Secretary to take into account this minutes of the meeting,
Lordship.
call for the vacancy position to which the petitioners can be adjusted. If such vacancy position is available,
As per 5%.
has to be appointed. If vacancy not available, tell them by
Yes.
communication that it is not available, we are extremely sorry.
Lord.
My lord, our case may be considered in other department also, my lord, as per.
Your
those-
cases will be considered only in the other departments because irrigation department does not have it.
My lord.
So, okay, we at 2 will dictate the order.
Lordship.
At 2 will dictate.
Declare. আমাদের affidavit এখন আছে ইয়াতে। এইমাত্র দিল। ইয়াতে তলত সোমাই আছে, তলত সোমাই আছে।
Heard Mr. You are F.A. Laskar?
My lord.
Heard Mr. F.A. Laskar, learned counsel for the writ petitioner. Also heard Miss M. Bhattacharjee, learned additional senior government advocate appearing for the respondent department. We'll stop. It would be the grievance of the petitioner as raised in this writ petition is that although the state level committee for consideration of the cases of candidates for appointment on compassionate ground in its meeting held on 2/3/2023 had considered the applications made by the petitioners and recommended, how many petitioners are there?
Three petitioners.
3. And recommended their appointment against grade 4 posts subject to availability of vacancy under 5% quota in other department, comma, no steps have been taken, no steps had been taken to issue offer of appointments to the petitioners. Full stop. The learned counsel for the petitioner has drawn attention of this court to the minutes of the meeting of the state level committee for appointment on compassionate ground held in the conference hall of the Chief Secretary, Assam, on 2nd of March 2023, where the petitioners, along with 6 other persons, had been recommended, had been considered for appointment on compassionate ground, and the 3 petitioners had been recommended for appointment against grade 4 post subject to availability of vacancy under 5% quota in other departments. Full stop. An affidavit in opposition had been filed by the Commissioner and Secretary to the Government of Assam Irrigation Department, wherein it had been stated that although the position of availability of vacancies was sought for from the other departments, the same had not been received till the date of filing of the affidavit in opposition. Full stop. It was further stated that if any availability is shown, comma, the applications and other relevant document of the petitioners would be forwarded to the concerned department for taking further necessary action towards appointment. Full stop. Another affidavit had been filed by the Chief Secretary to the Government of Assam, wherein a reference has been made to the new office memorandum issued on 18/9/2024, under which new office memorandum dated 18/9/2024 and an SOP dated 38/2025, where procedural guidelines have been mentioned to consider and dispose the application for compassionate appointment, and accordingly invitations had been invited, fixing the last date of receipt of application on 15/9/2025. Full stop. Ms. Bhattacharjee, learned additional senior government advocate, has submitted that the cases of the petitioner can be considered in accordance with the aforesaid OM and the SOP. However, the petitioners did not apply under the said advertisement, and therefore their cases are pending. Full stop. Next paragraph. Ms. So-and-so appears for the Department of Irrigation and has reiterated the position that the vacancy position from the other departments have not been received till date. Full stop. This court has considered the submissions made and the undisputed records available in the writ petition. Full stop. Writ petition. Full stop. It is not disputed by any of the respondents that the petitioners had been recommended for appointment against grade 4 post subject to availability of vacancy under the 5% quota in other departments, since there were no vacancies in the under the irrigation department to accommodate the petitioners. Full stop. It also appears from record that the petitioners had preferred earlier litigation, consequent to which the state level committee had considered their cases in the meeting held on 2/3/2023. Full stop. Since the cases of the petitioners has already been recommended by the state level committee also, comma, this court disposes of the present writ petition by directing the Chief Secretary to the Government of Assam to call for the records of the meeting of the state level committee for appointment on compassionate ground held in the conference hall of the Chief Secretary, Assam on 2/3/2023, and in case the petitioners are found to have been recommended for appointment against grade 4 post, comma, the Chief Secretary shall further call for the vacancy position in the other departments to verify as to whether there are sufficient posts to accommodate the petitioners as per the recommendation of the state level committee. Full stop. This court also notices that since the cases of the petitioners had already been considered and recommended comma, there would be no application of the office memorandum dated 18/9/2024 and the SOP dated 38/2025 to the case of the petitioners, full stop. The consideration by the respondent number 3 and further the recommendation to the consideration by the Chief Secretary of the Government of Assam by calling for vacancy position from the different departments and the final orders to be passed by the respondent number 3 with regard to forwarding of the applications to the concerned departments, comma, if any vacancy is available to accommodate the petitioners shall be done within a period of 3 months from the date of receipt of a certified copy of this order, full stop. The respondent number 3 shall also call for a compliance report from the concerned department if the cases of the petitioners are forwarded to any of the departments for appointment on compassionate ground, full stop. In case there is a lack of vacancy to accommodate the petitioners, comma, the same shall also be intimated to the petitioners by the respondent number 3 within a period of 3 months from the date of receipt of a certified copy of this order. Read petition disposed of, no costs.
Obligement.
Deeply obliged.
Hmm.
Like that petitioner has been removed from service after a department proceeding. And the allegation against the petitioner was that while serving as a circle inspector Kalipetia, and that he has demanded strike amount of ₹10,000. Now, my lord, we are challenging the award of penalty and the entire proceedings on a very narrow campus because there are inconsistencies and discrepancies in the witnesses, in the statements of the witnesses. So, my lord, there have been serious discrepancies. Would that, my lord, lead to my penalty order, my lord, that is a removal from service?
Your affidavit is filed, sir.
Yes, yes.
Ready for disposal.
Lordship, records will be required because here we have stated in the affidavit the statements of the witnesses. were not
When
annexed.
shall we call for a special messenger to bring the records? Tell us.
Dear Lordship, that is what,
Eh?
because we have stated in the
You are
affidavit.
defending your case and we are supposed to call for the
No,
records.
Your
No. Very well. Then when?
Then Your Lordship may fix it next week, Your Lordship, I'll get it. Or March 26th, not
Eh.
26th, Your Lordship, 31st.
Where is that order?
Impugn order is the, my lord, at page 66, my lord, 64, my lord, 64.
You have not given a copy of this memo number and a memo dated 35/2023. Huh? By which your inquiry report was handed over to you?
No, we have annexed, my lord, second support notice I have annexed.
Where?
Second support notice is lordship is fine. at 45, page 45.
What happened to the criminal case?
Spending. My only limited prayer before this honorable court will be matter that there are 7 PWs matter, prosecution witnesses, and there are 3 versions of the facts. They are all eyewitnesses and there are 3 versions. How can there be 3 versions and they can remove me from service?
But you have not given the prosecution statements.
No, I haven't.
The statements?
No, whatever has been given to me and with the inquiry report, I haven't.
Statements.
Yes, statement, I haven't. Yeah. It starts from my lord page 35. It starts my lord, the inquiry report. 1 minute, my lord. Witnesses statements, lordship will find from page 46 onwards, lordship will find. Page 48, PW1 starts. May I read it?
So the PSO took the money according to one of them.
Yes, ma'am.
According to the other,
According to the second, my lord, the complainant himself went inside. And no, according to the first, my lord, one boy entered and he came out. And the PSO came after to inquire who was the boy, and the money was handed over to the PSO as per PW1. Then as per PW 2, 3, and 4, the complainant, my lord, came, gave the money, my lord, and my lord, both petitioner and the PSO was complainant. And the third version is, my lord, that the PSO took the money and ran away. The vigilance officer saved him, caught him with the money, and he implicated me, my lord. There are 3 versions, sir.
That is the statement.
Yes,
We have
from the
stated,
witnesses.
we have stated in affidavit, sir. If your lordship browses through page number 87, para number 9.
Governor Fancy, my lord, on affidavit, it cannot be improved. Their witnesses, my lord, not mine.
We are just stating
PW1
what is
says
obvious, your lordship.
they was the hand of Digonto Borua. He does not talk about this person. Then PW2 says Digonto Borua. His hand was not washed.
No, before washing of hand, my lord, at page 49,
Just a minute.
then page 53, PWD 5, the third version.
Hmm?
Page 53, PWD 5, third version. Seventh line from the bottom. The complainant went inside the room of the CI Khalupetiya to hand over the tainted bribe money. They took the position as brief. The PSO of CI Khalupetiya was standing in front of the quarter of the CI Khalupetiya, came to take the money. Then his PSO tried to run away, but they seized and apprehended him. This is a third one.
That is regarding whether PSO ran away, whether who came in. What is the charge against you?
Against me, my lord, that I've taken the money, my lord.
Where is it?
Yes, my lord, the so-called message you will find that page 31. And statement of allegation at page 33.
Eh,
Wait,
What is the charge?
charge, break charge, my lord.
Yes, Mr. Bora. Once you have the records, you have to tell us what is the charge.
Lordship, otherwise the state,
Total.
that focus notice at the third paragraph, your lordship.
Ah,
Here, after the team of ACB, PS made a search in a government quarter. In presence, during search, an unaccounted cash amount of 4,68,000 was recovered from your government quarter. Therefore, you are arrested in connection with ACB connection fund forward to judicial custody. You are above act and tantamount to serious misconduct.
Which above act?
This particular act.
Receipt of 10,000.
No, receipt of 10,000 plus this unaccounted
Eh?
cash of 4,68,000.
Someone is, this PSO is arrested with the case. How is he responsible?
PSO himself said that it was at his direction. At the direction
Statement of accused being used for? Eh?
Lordship, that is there.
And so therefore we are asking, what is the specific charge?
And secondly,
He had money in his home unaccounted for.
and secondly, it is 4,68,000
Unaccounted, unaccounted money. Now, what was he required to show that the money was not taken on his behalf, or that it was not an unaccounted money, or he had to prove both?
We had to prove that first of all, we had to prove the departments that first of all that tainted money belonged to the petitioner. He was the main person who had actually directed the PSO co-accused to accept the bribe money. Secondly, was with regards to this unaccounted cash amount of 4,68,000, which was found in this quarter. That in fact we have this 4,68,000 we have stated in affidavit also.
Or is it because he got arrested? That is the charge. Thereafter he was arrested. His above act. Which act? It is one act, not S.
I'm looking at the statement of allegations, Your Lordship.
Last line. He is above act.
Yes.
Which act?
Above X.
Wait, no.
Above act tantamount. Act.
Tantamount is because act is singular. Tantamount will be plural.
All of this particular
acts. Tantamount.
that
Tantamounts.
tantamounts, Your Lordship. But
Where should the S have been?
This particular act of
Record.
getting this particular.
When? Record. Which is the act? Start with that. Which is the act?
I understand.
And then what did you prove? You proved that man ran away. And did you prove the 4,65,000?
Yes, we have said
That money is there. That noting. These are the money. This is the money recovered.
After the inquiry report, he had given an affidavit that this amount was actually I got it from selling my car, from Bolero car. So that is how we explained it after that inquiry. That affidavit was never taken to.
Which is that 4,65,000? Was it presented during the inquiry? No. When the money is not there, how do you proceed? Anyway, when do you want it?
31st, Your Lordship.
31st of March. List again on the 31st of March, allowing Mr. Bora, Learned Counsel, appearing for the respondents to produce the records of the disciplinary proceeding. Mr. J. Patwari appears for the petitioner. No, we have not heard it. We have only discussed it. Not heard it anything. Not heard it.
Yeah, please. Some time may be given, Your Lordship,
To
pass over for the today. I have some problem, Your Lordship.
Whether he agrees.
Shorter period, Your Lordship, this is long pending case. This is the third round of litigation.
Roster? Roster for what?
Roster,
To keep intact the roster, the prayer is
Here is
prayer is
very
basically,
peculiar,
Your
Your
Lordship,
Lordship.
for the payment of
Eh?
enhanced pay, Your Lordship, because the petitioner was placed under senior scale of pay with effect from 11/4/2007. Now.
how is your pay affected by the roster?
Roster is a secondary prayer, but our basic concern is the non-payment of his enhanced pay, Your Lordship.
But you have made the roster the first prayer
Yes.
Your Lordship,
Here is roster.
that was there, but
at the request of the learned counsel for the respondent, which is not objected to by the learned counsel for the petitioner. List this matter again on, tell us.
I think after 31st March.
6th of March, 6th of April, 2026.
15th,
6
6th March.
April. 6 March would be 1 year away, sir.
No, 6 April, I am not available, Your Lordship.
When are you available? Tell us.
Before 6 March. Second, third, whatever.
1st of April.
First of.
No.
And your Lordship, the department's affidavits not coming forward. Lordship,
They have not filed the affidavit.
Not yet.
To your benefit. We are not waiting for any affidavit, sir. If they have not filed it, it is to their problem.
Yes. Most obliged.
May pleasure, Lordship.
Hmm.
Your Lordship may kindly peruse the last orders of the Honorable Court. And by the order, the respondent number 1 and 2 were supposed to file affidavit.
He is under instructions not to file it.
My lord, this will do, my lord.
You are under instructions not to file any further affidavit.
So, my lord, we have already filed one affidavit by respondent number 4.
That will do.
Yes, my lord.
Further, I haven't, my lord, though I have written, my lord, I am yet to receive the instructions, my lord.
Anyway, let us see. Should we take it up for disposal?
Yes, here, my lord, the question of regularization of the petitioner services.
Hmm.
Yeah, the petitioner, he was appointed in, his father died in harness in 1992, and he was appointed as officers in 1993, and he was given the pay scales and all the service benefits, and including his provision fund has been also deducted. Everything was done, but his services has not been regularized. If it is so, then ultimately the petitioner will be deprived of the pensionary post-service benefits, my lord. And only one order is to be passed, that is the services will be regularized.
Huh?
My lord, your lordship may annex from my lord, Annexer 1, it is the letter of Undersecretary Government of Assam to the Chief Engineer. It is mentioned appointment on compensation ground. In inviting a reference to the above quoted letter, I am directed to say that the prayer of Sri Kurojit Das, son of late Nagan Das, driver for appointment to rural handyman, to hereby approve on compensation ground, subject to fulfillment so and so. You are therefore requested to take necessary action accordingly after obtaining PVR and verification of age, education, etc. Then, my lord, Annexer 2, it is written by Chief Engineer to the Executive Engineer, page 18. With reference to the above, you are requested to take necessary action for appointment in respect of Sri Kulojit Das, son of Sri Nagan Das, ex-driver on compassionate ground in the post of rural handyman as approved by the government by letter number 7. It was already approved by the government. But then Annexer 3, my lord, it is to the Executive Engineer by the Additional Chief Engineer. It is here, my lord, with reference to the above, I am to say that the appointment in respect of Sri Kulojit Das, son of Sri Nagandas, late Nagandas, ex-driver was approved by the government. It was approved. Right under letter under reference against the resultant vacant post of rural handyman as proposed by you, by the letter under reference, and accordingly you are requested to appoint Sri Das in the post of rural handyman from this and hide this office letter under reference. But as for the representation made by Mrs. Pujno Paladas, wife of late Nogan Das, it is seen that Sri Kulodis Das has not yet been appointed till that is in spite of the government approval to same. Hence, you are requested to take necessary action on the matter at early date. And also, you are hereby asked to.
You are not disputing Annexure 2, sir,
Not-
are
yes,
you?
Not disputed.
Are you disputing Annexure 2?
Not
My lord, we have disputed that he was, my lord,
Hmm.
not in a vacant post. He was appointed in a work charge establishment, my lord. Not, never in a regular vacant post.
Who did not appoint him?
His
In
appointment,
the,
my lord.
who did not appoint him?
My lord, the period.
My lord, let us then go into his appointment, my lord.
Ah, yes.
My lord, the petitioner, he has been given the revised scale, due increment, and the PPI, provident fund has been deducted. It is, everything was done, like, which is applicable to the regular appointee. Now, the petitioner, only thing is that his appointment should be regularized. That has not been done.
Hmm. Page 17, sir.
Yes, my lord.
Let us.
Page 17 is a reference, my lord. This is not his,
What is it?
this is, my lord,
In inviting reference to the above quoted letter.
my lord.
Just a minute.
Yes, my lord, yes, my
I
lord.
am directed to say that the prayer of Kulojit Das is hereby approved on compassionate ground, subject to fulfillment of the conditions laid down in government notification.
Yes.
You are requested to take necessary action accordingly after obtaining PVR and verification of and educational qualification, provided it does not exceed 5% vacancy.
Yes.
My lord will come to page number 24.
Then we will come to page number 19. Slow pace, sir.
My lord, my lord.
Okay, page 20. You are requested to take necessary action for appointment.
Yes.
With intimation to this office.
Yes.
Then page 23. Again, was approved by the government letter against resultant vacant post of roller handyman. It was approved by the government. You are requested to appoint Sri Das in the post of roller handyman. RA date you are asked to intimate within 10 days. Then page 24.
This is the appointment letter, my lord.
We'll read page 26. In the interest of public service and in pursuance of government letter number 1993 and chief engineer letter number 1993, appointed as work charge handyman on compassionate ground in the scale of pay. Huh? So?
So, my lord, this is a work charge establishment, my lord. Not in a vacant post, my lord. So that's why, my lord.
The
Since-
approval was for a vacant post.
Yes.
No, my lord, there was no vacant post. That is why he was given.
Then he should not have been appointed.
Yes.
The approval is for the approval of the appointment is there.
Yes.
My lord. My
You
lord,
were required,
My
the
lord.
appointing authority was required to say, no 5% vacant post, no appointment.
My lord,
No, he appoints.
that is what we clarified in the affidavit.
Ah,
We clarified in the affidavit that because of his, my lord, poor economic condition, he was seeking job. and we did not have a vacant post. That is why we gave him
Where?
in our affidavit, page 37,
My lord,
para 10.
compassionate appointment is always for regular appointment.
Para 10, my lord.
Order does not say so.
Yes.
That is why, my lord, it is work charge.
Work charge person is appointed on a scale
Yes, my lord, work charge are given scale.
in 1993.
My lord, most of the cases these days coming,
Huh?
my lord, work charge employees, they have a payment. They are given, my lord, but they are not in a regular establishment.
Hmm.
That is why, my lord, Upendas, in
Hmm.
Upendas, my lord, in para 22, my lord,
It is not
23,
applicable
my lord,
Hmm.
it is stated that the division has observed that workers and MR workers,
Hmm.
they will not get appointment, otherwise they will get all other benefits. That is what we quoted in our affidavit also.
That case is not applicable here. He is appointed on compassionate amendment. In case of this case, is generally the PW department and water resources department, they engage some persons on work system, right? That is a different thing. But here it is on compassionate ground.
We stated, my lord, in para 10, that with regard to statement made in para 16, recruitment answer deponent begs to state that the petitioner could not be appointed against a regular post as there was no vacancy, and due to his poor economic condition at that time was appointed in a work church establishment.
In so long, there was no vacancy. In 93, he was appointed. Then thereafter, no appointment has been made.
2000, page 27.
Right. Presently, the post of office peon is lying vacant in the office of the assistant executive engineer. Probably. 7. In this context, he may perhaps be regularized in the post of office peon at the office.
That is what it is clear, my lord. He was not appointed in a regular cadre, my lord.
And then go ahead.
Hence, he was inducted in work church establishment.
Hmm.
Subsequently, regular post fallen vacant after his appointment in work church establishment.
Hmm.
Did not qualify for the appointment.
We don't understand that line, but still go ahead.
Presently, the post of office peon is lying vacant in the office of the assistant executive engineer Borpeta, such and such.
Hmm.
Listening to duties. He is discharging his duties permanently, and there is no adverse report. In this context, my lord, the thing is that he was not.
Maybe perhaps regular.
My lord, his appointment was, my lord, then it becomes a, my lord, the thing is that he was appointed in the very first day in work establishment. This is a letter, my lord, written by executive engineer. But the thing is that, my lord, how we could have, my lord, he was appointed in a work establishment, there was a vacant post somewhere else, we could have brought him there.
Hmm.
And in 2005, we carried out, my lord, already one this regularization, my lord.
Did you include him? Did you include him?
His name was not there, my lord.
Whose fault?
Not our fault, my lord.
His fault.
Upendas clarified it.
His fault.
My lord, it didn't happen. But Upendas has, that's why Upendas has my lord, given them a shelter. That they will continue till they will get all other benefits except the pension. That is why, my lord, Upendas.
His appointment was approved on compassionate ground. Your engineer decides to do it on work charge. And now he's not entitled to regularization.
My lord, he accepted it. Work charge establishment, he should have denied. He did not deny, my lord.
No.
He
A person begging for appointment on compassionate ground will deny a government effort. Who is an undermatriculate, who does not, who would be the last person to understand work charge, master role, not in a position. 7th of April.
May it be taken as part heard.
7th of April. My list is showing too many part heads. Let us do some full heads, no part heads. What we will do.
May I pay for some accommodation for today? Can it be taken on any other date?
Huh?
Can it be taken on any other date?
My lord, actually, my anxiety is that they are filling this post. The direction is given 2013. This is NIT, your lordship, yesterday same method is there, but here issue is different.
Issue is they are challenging the appointment orders of the
Yes.
private
But
respondent.
they have always said that
Corporate
assured that we
response.
will going to appoint.
On the last occasion, I handed over this order by which these persons have already been appointed. So they are assailing the appointment orders of these persons.
My lord, this honorable division bench order as
We
well
need it
as
in the
this
next week,
single
lordship.
bench order.
Are you filing your affidavit in opposition?
It is done, lordship.
Huh?
It is done.
Affidavit is in file?
Yes.
Records.
But in the record, it is not showing. There is some, probably it is lying defective or something like that.
Huh?
Probably it is lying defective. I have seen it, but it is not there in the record.
The affidavit in opposition stated to have been filed
Yes.
by the on behalf of the respondent 225 is not on record. List again on
First week of April, lordship.
8th of April. 8th of April, along with the affidavit in opposition filed by the respondent number 225.
Copy may be-
Petitioners would be at liberty to file their response. Give him a copy today.
Copy, yes, my lord, copy, sir. Complex.
It has a total.
Maybe for time.
Time being.
16. My lord, dismissal, affidavit not filed.
I'll pay for some time, my lord. Order 3 weeks time, my lord.
Some financial irregularity is also there, sir. Like also.
At the request of the learned counsel, Mr. G. Pegulanet, counsel paying for all the respondents, seeking an accommodation to file the affidavit in opposition.
My lord.
List this matter again on the 20th of April,
After 22nd April, my lord.
after 22nd, 24th,
My lord.
24th of April. Petitioners would be at liberty to file response to the affidavit in opposition, if so advised.
17.
Then also, my lord.
Same here, lordship.
Say what? The
For
respondent
the date,
counsel
just need
would
some
like.
accommodation for the date.
Huh?
Not in 24th, lordship, otherwise on 25th or
26th or 27th?
27th.
Date to khali bodli.
18 or 19.
Hello, your lordship may kindly take item number 19. Question is whether he was transferred, whether on transfer he will lose his seniority. That is the case.
How can?
That is what they have done. My lord, your lordship will kindly see this petitioner, page annexure 2, page 26. He was promoted to the post of UAT.
Page 20.
26, 27, my lord. Twenty-six is the type copy. This is dated 2018.
No, what does it say?
2008. Persons to promotion so and so, Biman Bora, LD assistant, office
No.
of the, they were
26.
promoted.
Page 26 is something else.
No,
It is some order dated 18/5/2024.
this is item number 19 I'm taking. 5275.
Lordship, if
Eh.
possible, can this matter be taken up any other day? There is actually a personal hearing matter going on in court number 10. Main
Okay.
counsel arguing this case is Mr. B. Gogoi.
I'll complain on the last occasion also they took time for filing affidavit.
But we have filed our affidavit in this case.
No,
Lordship.
I would like to complete it.
Let him complete.
come forward.
Lordship.
It's
We'll
very
We'll take it up
simple.
tomorrow, on Monday for you.
Lordship, actually, this might require some hearing. That's why Lordship was
Tuesday?
making it possible. Lordship,
Tuesday?
I'll complete mine. Let them.
can it be on Thursday, Lordship?
Taking time.
Huh?
Can it be on Thursday in that?
Thursday. We'll
Lordship.
hear him today. We'll fix it on Thursday for you.
Lordship,
Will do?
Lordship.
Yes.
Will not take much time, my lord. This is page 26. He was
Huh.
promoted to the post of UDA. my lord.
Hmm.
2008, your lordship will can listen. Then he was transferred to Dhamaji, 29. 2018.
Hmm. UDS. In the same capacity then?
Yes. Then, my lord, post fell vacant, para 5, page 9. Post of
Page?
para 5, page 9. Post of head assistant fell vacant, that is
Ah.
superintendent post.
Hmm.
In the year 2024,
Hmm.
1/12/24,
Hmm.
we filed the application, then page 31.
Hmm.
His name was forwarded.
Hmm.
His name was forwarded
Hmm.
for his promotion. Then, my lord, gradation list, your lordship will can see page 32.
Hmm.
33 is the promotion, my lord, gradation list.
Hmm. You are number one.
I'm number 1. Date of promotion is 2008.
Ah.
And the respondent number, private respondent Nurul, 2011.
Yeah.
So accordingly, my lord, he is the petitioner is the senior most UDA.
Hmm.
Then your lordship will kindly see page 35,
Hmm.
gradation list of UDA. Then
You are
your
number
lordship
2.
get page 36,
You are at number 2.
number, now I have been made number 2,
Ah.
number 2.
Hmm.
Now, page 41. This is 2019. Gradation list maintained.
You are at number 5. Why?
Number 5. So this, thereafter, my lord, gradation is again prepared at page 45.
Hmm.
Now, the fresh gradation list is at page 60.
From 40 we go to 60.
60.
Ah.
The impugn letter. There, Biman Bora is serial number 3. Private respondent number is, that is on the basis of date of joining.
Date of promotion. UD. Date of joining of what?
Date of joining in the office, because the Biman Bora petitioner has joined office in the year
Ah.
2018. Now, date of promotion has not been shown here.
Hmm.
So on the basis of this, they are saying that your fresh gradation list is there, so you are not senior.
Hmm.
So now what they say in the affidavit is page 33, my lord. Affidavit just narrates the fact, my lord. I will just read this. Paragraph 4, my lord, second paragraph. Deponent begs to submit that a previous gradation list dated so and so, dated 2019 was again
Yes.
followed. and
This
submitted-
gradation list goes to one ground. You did not deem it fit and proper to inform the persons whose seniority you are changing. Have you seen the affidavit, sir?
Yes, Lordship. Yes. And on
Do you endorse to that? Do you think that is a correct statement?
I believe, my lord,
Have you seen that, that at page 6 of your affidavit, running page 72, para 9? Found it? The last line in para 9. Further, the deponent begs to state that he did not consider it necessary to inform the petitioner regarding preparation and submission of
Well,
gradation list.
Lordship, because the previous gradation list was already cancelled. That is why, Lordship.
Sir, you are not only a department's representative. Kindly tell us a gradation list without objections, without provisional gradation list.
on the basis of date of joining, my lord, they
No,
can.
no,
do it.
on the basis of whatever.
Lordship, but the previous gradation lists which were there, they were possibly misused. That is why it was taken.
Misused? How can a gradation list be misused?
Lordship, because there were certain infirmities in those gradation lists. That is why they were cancelled.
Huh. And then when you make a
Then a
fresh gradation list, what do you
was
do?
issued.
How is a fresh gradation list made?
Lordship, by taking into account the service record.
And initially, what kind of a gradation list is made? Provisional gradation list. Asking for objections, clarifications, circulated,
Lordship.
considered, finalized. Provisional gradation list if challenged, premature.
Lordship.
You are preparing a gradation list and making a statement before this court on oath. I don't think it necessary to ask. I am determining his and his seniority. I don't deem it fit to necessary to ask.
Lordship, but the
I am the boss. Huh?
Lordship, but the seniority of the private respondent who we have considered, Lordship, there is sufficient grounds as to why he
What
was
is this? What is the settled law regarding transfer and seniority?
I'm not aware of that.
Only when a transfer is on own request,
Lordship.
a person will lose his seniority in the cadre.
Lordship.
If the government asks you to go and serve somewhere, can you lose your seniority? Who will go and join? Everybody will be before
Yes,
this court.
Yes, Lordship.
I've given one judgment on the same basis, my lord, that flag A. Para 16, 17.
In your entire affidavit, you have not said why this seniority has been.
Lordship,
Yes.
we take into account the affidavit in opposition which we had filed in the previous petition, WBC 1350. 1350.
What have you said?
Lordship, kindly refer to page number 36 in that affidavit. Point number C.
Yes, that is what we are asking you.
But he had been transferred from that district and he was already serving in Dibrugarh district.
Huh.
That is why he was considered.
Cannot be. Why it cannot be? Person is how do you say it? Asking a person to lose his seniority on transfer, is it not penalizing him? Let us see the chart.
Yes.
What do you say that? The gradation list that you have cancelled. That page 29. On the next occasion, in the absence of the other standing council, you would have to answer the issues. If
Yes,
we
yes.
keep it on Thursday, we'll finish it.
Lordship.
Page 29.
Page 29. Of 5275, Lordship.
Of your writ petition, the one you were referring to.
Lordship.
1350.
1350.
Huh, have it. You were showing us 1350. Okay, you have the other writ petition with you.
Yes, Lordship.
We'll do it with that. Yes, come to the other writ petition. Yes. Come to page 37,
57.
annexure 9. The seniority is to be seen as what? In the post of UD, is it? In the
Yes.
post of UD, we are trying to look at the seniority, huh?
Lordship.
You have page 37,
Yes, Lordship.
annexure 9.
Yes, Lordship.
Ashok Kumar Phukon. He joined services when? 1983.
1983. Yes, Lordship.
Promoted when? 2007.
7.
Okay. And order number promotion is 2007. Done.
Yes, Lordship.
Biman Bora. When did he join the service? 95.
95.
When was he promoted as a UDA?
1/4/2008.
Ah.
Lordship.
Now is Nurul Islam. When did he join services?
1/1/1999.
So he joined 4 years after Biman was already a UDA? Yes?
Lordship.
Now, when was he promoted? 2011.
2/7/2011. Yes.
Huh?
Lordship.
3 years later. Is it?
Lordship.
So who will remain senior? The
Based on
transfer is not on his own request.
No, no.
Transfer is not as a penalty.
Lordship.
Is it? Thursday.
Thursday, Lordship. I'll obtain whatever.
Place this matter again on Thursday. Ki puribo hai? 19th. Thursday 19 niki? Huh? On 19th
Lordship.
of March for further hearing. Unless you can show that it was a penalty transfer
Or on his own request.
or that it was on his own request.
Lordship.
Nothing else works.
Lordship.
And if it was a penalty, then you have to show that there was a proceeding before that.
Proceeding. Departmental. I understand, Lordship. Perfect. Much obliged.
Lordship heard them.
List on 19th for further hearing, we said.
Obliged.
Before my line of friend start, my lord, I received the instruction as well as paragraph comment, my lord, today morning. So I pay some accommodation to file our affidavit.
What is the grievance?
Just very briefly, may I explain?
Huh?
Very briefly, may I explain the facts, my lord, very briefly.
No, just tell us the grievance is
The
this.
petitioner herein is the, my lord, sole social science teacher of the
Provincialization.
provincialization, my lord.
You will have your benefit from the date when it was given to the other fellow. No hurry as of now, let them have the affidavit.
I am the sole, my lord is correct, I am the sole social science teacher, and my lord, the 2 language teacher has been provincialized. My lord, in spite of my lord, the petitioner being the social science teacher, in fact, it is the, my lord, second round of litigation, my lord. On the earlier occasion, we have a, my lord, different appeal, my lord.
Where is the first round of litigation order?
My lord, initially, my lord, interim order was passed. Thereafter, my lord, we have been directed to prepare an statutory appeal. My lord, will file this on that on page 47, my lord.
Huh?
47, and the appeal, the impugn order, my lord, will find on page 8.
Wait. The
Impugn
moment
order
you
that
say there
my
was
lord is
an
expected
earlier
to
order.
litigation.
Huh?
Herein, my lord, herein fact is that, my lord, that we have succeeded in the appeal, my lord. that the Secretary Education, School Education has given an observation that the recommendation made by the DSC is not according to the section 3111 of the 2000 Act, two language teacher has been provincialized, and it has been directed to the DSC for reconsideration of this recommendation. That was there. Thereafter, DSC, instead of recommending my name, what they have done is that, the Lordship, you can just for a moment turn the page 58, 58. They have, take some resolutions. File take.
Notun Haldibari.
Yes, Notun Haldibari, no, not 58, Balijan, Janodati ME School.
Balijan Janodati Vidyalaya Pradhana Prakshikam পদত নিযুক্তি দিয়া শিক্ষাগত অৰ্হতা সম্পন্ন কুশল শইকীয়া সমাজ বিদ্যা পাঠদান দায়বদ্ধ কৰা হয় আৰু আসাম ইমান অনুসৰি আজিৰ সভায় পৰিচালনাৰ ইংৰাজী ইমান তাৰিখে সেক্ৰেটাৰী আদেশ অনুসৰি পুনৰ অনুমোদন জনাবৰ বাবে ঊৰ্ধ্বতম কৰ্তৃপক্ষলৈ প্ৰস্তাৱ পঢ়া they forwarded it.
Yes, man.
You are কুশল শইকীয়া.
No, I'm not Kuko Hoge, I am Bhupen Kuli.
Who is Kuko?
Kuko.
Kuko has been served.
Yes.
You have been served. What do you say? Today.
I have signed on the very first day I have served,
How could you?
Oh,
He's for the private respondent. Caveat.
I got it from the council respondent number 7. Let me take some time and file an application.
No, that is his problem. When I have filed.
Let us not play fault, huh?
Only, only aspect is that, what they have, resolved DSC, what, they have in resolution, they are saying that the headmaster of the school, even though he is a language.
Okay, you want a disposal today?
No, I'm not. What only, just I'm trying to substantiate only one, fact, virtually, virtually what they are trying to say is that.
What? Except allowing them to file their response. What more you want us to write in the order? Kindly tell us that.
Absolutely.
Anything more?
No, nothing. Only that virtually they are manipulating the documents. That stings. But subsequently, I am a social.
Let them manipulate by way of an affidavit.
Yes, my lord is correct. Now, the recommendation, wherever they are sending to the authority, the headmaster's name has been inserted as social science. So, my lord will 67 page number, 67 page number.
Provincialization of the service of 6 and 7 are subject to outcome of the writ petition.
My lord, that order
you want a complete stay?
No, I'm not.
That order was passed on 16/5/05.
Yes, my lord. Let them, file the application.
List again on when, by when will you file it?
After 2 weeks, man.
List again on
Immediately after review vacation, man.
22nd of April.
My lord.
Allowing Mr. Talukdar, Learned Council, representing the Department of School Education. Respondent number, how can you have two respondent number 7s?
And 6.
Mr. N. Akhtar. And Ali on behalf of respondent number 6 and on behalf of Mr. He's a party here, Mr. P. Mohanto.
Yes, sir. Senior.
Respondent number 7. Petitioners would be at liberty to file their reply before the next date of listing.
Oblige.
22.
Yes.
My presentation. In this litigation, we had challenged the show cause notice which was issued to us based on the. We had challenged the show cause notice which was issued to us based on the findings of the Justification Inquiry Committee. Lordship, we had challenged the validity of the inquiry report. Lordship, their time told that has already been reserved for judgment in a coordinate matter. What is more important is that, Lordship, in this matter, the show cause notice contained no list of witnesses. And the day on which the show cause notice was served upon us, on the same day they appointed inquiry officer and presenting officer. And they went ahead with the proceedings. The Lordship will see the show cause notice that is at page.
The Lordship, before my learned friend starts, the Lordship, here in this matter, Mr. Nalim Kohli is leading this matter. So, and also Mr. Dipankar Nath is there. So I have to inform Mr. Nath whether
What has happened to the show cause notice? It has culminated in something or it is,
No, Lordship, the proceedings are
at
still.
what stage is it?
Lordship, the notice on interim was issued on 26th, considering the interim to be considered on the returnable date.
26th of May.
26th.
Till now, what has happened is what we are
Till
asking.
now,
you.
Lordship, I had inquired from him, no final orders have been passed, and
Enquiry is completed.
Enquiry is
Enquiry
not
report has been
completed.
given.
no, Lordship. Inquiry is not complete. Lordship,
You have
kindly-
not filed your affidavits also.
Your Lordship, I'm not aware, I'm not in this particular case, so let me just get.
If the persons aware are not before us, what do we do?
So let me just, after your Lordship, and pass over timing, I'll just get.
Let him have his information, what are they doing? 2025,
If I-
dismissal is yet to come. They have challenged the proceedings
Proceedings.
at the appropriate stage. Find out, we may go for an interim order,
Like,
if he can convince us. All of this.
23.
In this matter, my lord, the instructions still awaited, my lord.
Hmm?
In the instructions still awaited, my lord.
Someone special is required to come.
Oh, my lord, the matter is challenge the order of 2014, my lord.
Hmm.
And
2000? You are challenging an order of 2014.
my lord, page 36, my lord, annex of 4. Page 36.
Where is the earlier order of this one?
Page number 30, my lord. 11%, my lord, page number 34, paragraph 15.
Then what happened?
Thereafter, they passed this,
Then what happened?
they filed contempt. My lord, this order passed and have accommodate as. As. They had accommodated, my lord, on, my lord, some agreement that they have not claimed the earlier benefit, my lord. So that agreement, he has challenged, my lord.
Where is that agreement?
Agreement not annexed, my lord, but kindly see the prayer portion, my lord, page 16.
No, it is there, page 36.
My lord.
Page 36.
Second paragraph is there.
2014 you are challenging now.
Yes, ma'am. Now I am claiming area salary as well as pension. Let them file affidavit.
That is the best way out today. List again on 20th of April. Allowing Mr. B. Talukdar, the learned counsel appearing for the Department of School Education to bring the response of the department on record by way of an affidavit. Look. Affidavit.
Sir, the instructions we received were not complete.
Get Mr. B. Chaudhary. He says the instructions had been received. Why did he lie?
Instructions- Yes, sir.
He lied to the court.
No, sir.
You have the instructions. Have the instructions been received? Yes. Why the affidavit has not been filed?
Instructions were incomplete.
Matter relates to the order of penalty imposed upon the petitioner, stopping 3 consecutive increments with cumulative effect, full stop. The learned counsel for the respondent has prayed for some time to file the affidavit in opposition. On 28/11/2025, it was stated before this court that the instructions had been received. Today, a statement has been made that the instructions received are incomplete, full stop. Accordingly, list the matter again on 22nd of April 2026, allowing the respondents to file their response. Stop.
The Lordship, I just been informed, Mr. Nath is in bereavement. So
Oh.
he is not in court today. So, Your Lordship, if I fix it next week, Your Lordship.
Okay.
Showing his name, Your Lordship.
Huh? Itu gimana item 22? Yes. We'll have it on the 27th. And anything happens before that, you move an eye if you get the inquiry report.
I have taken instructions on 9, the last hearing was conducted except for a last.
Huh?
On 9, last Monday, Lordship, he was again called. Few questions were asked, but nothing thereafter because there are no witnesses.
You do not have any proceedings going on at this moment.
Lordship, it's going on, but since there are no witnesses. there is no discovery.
Whatever it is, but
It's going on, Lordship, but the inquiry report has not been filed.
let them file their response. With the submission made, we are not passing any orders today. List again on the 27th of March or later?
27.
27th of March,
27 of March.
allowing the respondents to file their affidavit.
Right. Your Lordship, the name of senior government advocate may be reflected in the cause list.
Cause list to reflect the senior government advocate for the respondents.
May it please your lordship,
Hmm.
the petitioner herein are optometrists in BSc. Now, there was a disparity in pay between the BSc optometrist and the technicians. That is the ophthalmic assistant and orthoptist. Those are diploma holders post, but they are drawing the pay scale of more than us.
Hmm.
So we represented the matter before the 7th pay commission. So if I may draw your lordship's kind attention to page
But
2.
then this will require some hearing, Mr. Sinha.
Yes.
It will require some hearing.
Yes, your lordship.
We'll take it up on 2nd of April, Thursday. It's the matter again on 2nd of April. Pleadings are complete.
Yes, your lordship.
Complete.
Pleadings are complete.
Deeply obliged, lordship.
Yes.
In this case, the respondent side on the other stated that the hearing took place in respect to the petitioner's declaration of the service. They were supposed to submit a report.
That only 3 or 4 days, Your Lordship, because it's already drafted. It's yet to be signed by the concerned officer, Your Lordship.
The report will be drafted and signed. You are lucky they have not said we'll file an affidavit. That would be 3 weeks. Yes, when? At the request of Miss H. Tarankpil Learned Council representing the Department of School Education. List the matter again on
18. My friend is asking for 18.
18?
Yes, Your Lordship.
18th of March.
Plus.
Yes, ma'am.
27 and 28.
Lordship, as per Lawazama court order, service on respondent number 3, 4, and 5 is completed, Lordship. Matter is not releasing his salary, they have already retired, Lordship.
Who is 3, 4, and 5?
Artfed.
Huh?
Artfed, Lordship. Managing.
From Apex Weaver and Artisans Cooperative Federations Limited.
Huh.
I'm not appearing for the Malin. I'm not.
None appears for them.
On appears also.
They don't have a standing council Malin actually. When
Huh?
They do not have a standing council. When they receive,
They have received.
they engage someone Malin.
They have received, but none has. And who will pay the salary? They will pay the
They
salary.
will pay the salary. It's a,
And why is the salary held up? A year salary, why is it held up?
Salary has been paid intermittently, Lordship, because of non-availability of fund, and they have not, they have already retired, Lordship. And one person has been expired, Lordship, and her legal heir has been implemented here in Lordship, as per made party, Lordship. So matter is urgent, Lordship, only for this, there is an order from this honorable court, Lordship. According to that,
Why only petition number 3 to 6? Why not the rest?
Lordship finally take up past the item number 28, Lordship. 6340 finally take up customers.
Hmm?
They are 1 to 7 were the employees of Artfed Lordship. Petitioner number 8-1 and 8-2, they are the legal heirs of one Onchumoni Besbora, who was an employee of Artfed Lordship. She already expired, so I made party the legal heirs of that Onchumoni Besbora.
Hmm.
They were working in various capacity, Lordship. Sales assistants to branch manager, Lordship.
Hmm.
They have already retired. And but for their service, during their service, they have not been paid salary regularly, Lordship.
Hmm.
And because of that, they have approached the Honorable Court to release the salary, Lordship.
Hmm.
All the employees has been retired.
my lord, may I suggest, my lord? The thing is that since they are not here, what I can do is, as an government council, I can communicate to them, the MD. That I can do.
None appears for the respondent number 3 to 6. 3, 4 and 5
3, 4, 5.
in both the writ petitions. Mr. Ardhork, not an additional senior government advocate, comma, on a request made by this court, has agreed to contact the officers of the
MD,
to contact the managing director of the
Artfed.
Artfed and inform this court the next date fixed. List again on, when can you get it?
I will send the letter by tomorrow, my lord.
25th? 25th of March? 25th of March 2026. Since the matter relates to the payment of arrears salary to retired employees and or their legal heirs. Let him find out whether they want to be represented or not.
Petitions are there, Lordship. One is for salary and
Order is,
other is for gratuity and leave salary.
for arrears salary jot likhisile je, and other retired benefits.
Obliged, Lordship.
Yes.
May I please, Lordship?
We have a small issue in this case, Lordship. Lordship, the matter relates to selection and engagement of Anganwadi worker and helpers. We participated in the selection process. Our name has been forwarded to the director for approval. But the director declined to approve the panel. The reason, Lordship, that he has given, Lordship, just one paragraph of the affidavit filed by the director, that is paragraph 4. Paragraph 4. Page 43, running page.
None is being approved, none is being appointed.
Well, initial advertisement that was cancelled.
You want it to be enforced. When the department says that the selection procedure is not in accordance with law, We had planned to rationalize it. The ICDS project person, child development officer says rationalize it. Then without rationalizing, she is holding the selection process.
Their own record, Lordship.
So us,
Come to page 53, 52 and 53. But the child development project is project officer is saying that after rationalization process he has started. And
5 have been rationalized.
no,
36 were required to be rationalized.
your Lordship will kindly see what he has done. In RTI reply, he has said that he has carried out the rationalization process.
But
May
to
not,
the,
may not amalgamated all the Anganwadi center. Those are necessary, they have amalgamated. Lordship, page 52, this is the proposal for approval was submitted by the CDPO. And after getting approval, the selection process was initiated. Page 53 is important document that they have with them this document.
Your Lordship may also see from whom that particular letter has been issued, by who, and the date also.
where?
The page 53.
After getting this approval, Lordship, page 53, the selection process was completed, initiated, and panel was submitted. So this has the approval of the Director, Women and Child Development Assam. Last line, your Lordship, see. This is the letter of the Joint Director with the approval of the Director. After that, the interview was held and panel was submitted. So, and your Lordship, if your Lordship kindly come to page 51, our RTI reply, what the CDP has said. Point A and B, your Lordship will see.
Yes, where is the point A and point B? Where is the reply?
Reply page 51. 50 is the RTI application and 51 is the reply by the CDPO.
No, I'm not understanding. Annexure A for your reference. What is annexure A?
Annexure A, Lordship, that is the page 52.
Yes, what were you saying, Mr. Bora?
Your Lordship, at page number 52, last, just after that particular column, after the table, moreover, after the column, moreover, an advertisement for filling up a vacant position of Anganwadi help worker and Anganwadi helper was published by order number so and so, dated 4/3/2024. Your Lordship may note down the date 4/3/2024. The selection process has not yet been started till now, since necessary approval is not getting from your end. And this letter was dated 10 July 2024. Thereafter, the Joint Director on 29, next page 53, 29A 2024, wrote to the Lala CDPO that with reference to the subject cited above with regards to permission to continue previous advertisement for fresh engagement. So it is to inform you that pursuance of your communications, you are allowed to conduct interview as per advertisement prior to amalgamation process prior to amalgamation process for engagement of Anganwadi worker and helper by strictly observing all formalities as per guidelines and without any legal compliances. Further, you are requested to submit proposal to understand for approval of select list in due course. So this was prior to, if suppose, prior to the amalgamation process, which had not happened. Prior to the amalgamation process, no problem. But the rationalization has not been done yet. So this rationalization process,
This lady says that rationalization has been done.
if I may state this, produce this particular instruction which I placed on last occasion and which has been stated in the affidavit, this is more detailed. Same thing has been stated in the affidavit also. So, second paragraph, thereafter, first advertisement was cancelled. Thereafter, another advertisement was published on 4.
So this ICDS project officer is lying.
So he is contradicting himself. And of course, that same officer doesn't remain. Earlier, he has changed. Now, a new incumbent had actually come into his place. So, if he has floated that particular advertisement, it was without any kind of authority approval.
Then what about your deputy director writing that, joint director writing that, please go ahead?
That was if prior to the amalgamation process.
Huh?
If it was conducted prior to the amalgamation process.
No, it
Which
was not
not done.
conducted, sorry. If it was published.
Yes, I'm just sorry, I forgot the language, Your Lordship. You conduct interview as per prior
See,
to amalgamation
yeah,
process.
no. Either we are not getting it or you are not getting it.
Published prior to.
There was a notification
Yes,
on 30/11/2023
yes.
that advertisement published on 21/9/2023 is cancelled.
Cancel.
So there can be no approval for that.
Because there was no rationalization being done.
There was no approval for any advertisement. Yes, with or without rationalization, whatever is the advertisement, it goes.
Yes.
Then what happened?
Thereafter,
Fresh advertisement will be published after completion of rationalization of Anganwadi Centers project.
yes. So,
The ICDS project, the child development officer says, I have completed the rationalization. I have brought in people in these 4 centers. Others rationalized, but people are not coming to join. The honorable MLA has said, don't transfer anybody. So they are lying vacant. And I have also published an advertisement because fresh advertisement will be published after rationalization.
subject to approval.
Where is
Page
it?
52, Your Lordship. As I said, moreover,
What
that
subject to approval?
since necessary approval is not.
Selection has not been started because the
Yes.
approval is not there.
Yes.
So advertisement has come.
They,
Selection has not started. Rationalization done.
he floated advertisement. He was actually seeking a post facto approval. Why? Because he's saying that moreover, an advertisement for filling up a vacant position of Anganwadi worker and helper was published. White order dated so and so, dated 4/3/2024. The selection process.
Are
was
you saying that
stated.
this particular ICDS project, Mr. Uddhav Bodoloi,
The board.
he has messed it up?
So it's
So what action have you taken against him?
we have not taken any action.
Then-
I'm not aware of that particular.
Find out.
But he himself has stated that
Selection process started.
started without approval.
How can?
No.
After getting approval,
This 10 July letter itself says.
What does,
10 July letter itself says, Your Lordship.
then what does 29(8) do?
Oh, 29, yes, after.
What is 29(8) doing?
29/8 is after 10 July, Your Lordship.
So he's saying that you have the approval, go ahead.
Provided, that is what, there is a condition there.
What is it provided?
You are allowed to conduct interview as per advertisement published prior to amalgamation.
That is
process.
already you have cancelled, you are stating in your affidavit that whatever was done is cancelled.
Cancelled because amalgamation for this
good.
particular center had not taken place, rationalization had not taken place, Your Lordship. That is why they have.
No, I have not understood.
Your Lordship, that is what we have stated, because the rationalization had not taken place. That's why
My lord,
we
my-
cannot approve it.
My friend is trying to confuse this. If you
No,
lost.
I'm not trying to confuse, that is a very wrong language you are saying.
We have seldom found him doing that.
No,
Don't,
that is-
don't
that is-
level,
I strictly-
aspirations over the
I have
counters.
Observations
Your
regarding that,
friends.
Your Lordship.
After all, your friends, professional friends. Don't say all those things.
My lord,
We
page
don't appreciate.
52 and 36, your lordship will see. Page 52 is the letter dated,
Eh.
sorry, page 53, letter dated 29/8/24. And after that lordship notification was issued, that is page 36, informing the candidate for appearing in the interview. So after that selection, interview was done, panel was submitted.
Where is 30/11/2023? What
Yes.
is 30/11/2023?
Yes, yes, I have an lordship, page 17,
Huh?
17, 170.
Take it up on a hearing day. But Mr. Bora,
Your Lordship,
by 30 November 2023, where you are saying that he's contradicting himself.
yes.
By 30 November 2023, you have cancelled an advertisement
Yes.
dated 21/9/2023.
Yes.
Fresh advertisement will be published after completion of
After
rational.
completion of the.
Now, the RTI thing that has come. What we are understanding, we are telling you next, on the next step, we'll try to understand something.
Yes, Your Lordship.
At page 52. No, sorry. At page
51.
51, he says it is informed that the rationalization process was completed.
He says, the CDPO says,
Ah,
CDPO says, but the
The- the-
director has not said. Your Lordship.
the letter dated 30 November is from the CDPO, not the director.
And that is dated 12/2/2026.
What? That is the reply
page
dated.
51. Yes.
That is the reply dated.
Reply, Your Lordship.
Now this, he says annex, page 52 is the annexure A to it, which is dated 10th of July. And in the 10th of July, this person says that status report of absorption of so-and-so from amalgamated so-and-so against the vacant post. 4 people have come, 2 people have come, 1 people have come, 2 people have come. The rest, they are not joining because of the distance, and Honorable MLA tells us not to transfer. So from my side, rationalization complete.
Complete.
What more to be done?
Now, of course, the director is approving authority.
Approval of what?
So approving of this whole select list.
Yes.
And director.
This
in
4-3,
affidavit.
that record, huh?
On affidavit, he has stated that.
I have
this
not
part-
approved.
I
He
have
has not approved
It
what?
cannot be approved because rationalization has not taken place. So he is the final authority.
From where does he say that the rationalization is not complete?
That is what the director is stating on affidavit as well as the instructions, Your Lordship. That is what. I'm just stating what is stated in the affidavit, Your Lordship.
And that the person who has completed the rationalization.
Now come to the 4th of March 2024. At page 18. In pursuance of government notification so-and-so, subject to approval of the directorate. Right, order dated 22nd of August 2023, applications are hereby invited. Yes, this is an advertisement given by the Department of Women and Child Welfare,
Child
Hailakandi, Office of the CDPO. Yes,
This is
people
CDPO.
have responded to it. The director would not have been oblivious of it, or only he remained oblivious that he does not know what advertisement are being issued. Cannot be. when the director has also been given a copy at page 24. Yes, now pursuant to this, your additional director says, go ahead with 432024. And your director says, no, I have not approved it. Your joint director says, this is issued as per approval of the
Right,
director. Then
but director says in the affidavit that it's not rationalized.
means,
I'll have
by
to get
name we shall have to call them,
No, your lordship, I'll get a
or will there be a
clarification.
better explanation?
Your lordship, I'll get a clarification. as
Now
to-
you have understood.
Yes, I have understood, your lordship. I have
It
understood.
is
it.
difficult to express it on this, but yes, something is wrong here.
Yes, something is wrong, but that is what.
List again
Director
on the
is saying something,
26th.
Director is saying something. Director
List
is
again
approving
on the 24th of March, allowing Mr. Bora to have his instructions.
Sparta, lordship.
Eh?
Sparta. Already your lordship has gathered.
Thumbs up, we'll do it. Thumbs up, we'll do it.
Bro, I was expecting an affidavit like it as directed, but no affidavit has come. The matter is also urgent. It has to do with selection for a physically, by the disabled person, for the post.
Yes, I think this was an issue in other writ petitions also.
Yes, lordship.
What happened there?
Lordship, their lordship, those writ petitions were dismissed. Thereafter, lordship, the petitioner filed a writ appeal. Then when the writ appeal was about to be dismissed, he sought liberty to file a review. Review also got dismissed.
Mm.
Now, lordship, that review is challenged by way of a writ appeal, lordship. That is fixed on 30th of April. That is writ
But
appeal.
this question that whether the disability certificate
No,
would
my lord,
prevail
issue-
over a medical board.
No, here, lordship, that prayer is not there.
No,
They are
no,
even
in the
seeking for-
backdrop, the order records it, sir. I'm not on the
Yes.
prayer, I'm on the order.
Then lordship has to come after lordship 30th of April, lordship, because that appeal is pending, lordship.
No, your lordship will see,
Writ
my lord,
appeal
the
number
impugn order.
37 of
The
2026.
impugn order is at page 57,
Uh-huh.
whereby, my lord, I have been disqualified, saying that page 57.
Hmm.
At the bottom, the petitioner, my lord, serial 5, clinical and investigation findings not correlate with certified data. But
Page?
page 57, this is absolutely non-speaking, man, what they are trying to say. Now,
You
my
are?
lord, the official documents.
Serial number 5,
Serial
lord.
5, man. Comments, your lordship will look up the comments at the.
Where is your certificate?
My certificates are 1, 2, 3, 4, man.
Acha, in those cases, they had agreed to a review medical examination.
No, no.
Review medical examination found them not fit.
Yes, lord.
Was it not something like
Asked
that?
for reassessment by the,
They had asked for reassessment.
they went and they participated.
They
and were
participated,
not
but here
satisfied with
the
it.
question is totally different. Can you override it?
Lordship, then lordship, the appeal is pending, lordship, before the,
Is it pending on that issue?
yes, lordship.
My lord,
That
this certificate
order,
was
lordship,
made on that day itself, but this
No,
court, my
lordship.
lord,
that day, lordship,
didn't hold it to be, my lord.
that order is of 26 to 2026, lordship, the writ appeal order.
Huh?
Writ appeal, there are. Writ appeal 37 of 26. Order 26 February. Writ appeal 37 of 2026, order dated 26 to 2026.
So, a certificate issued by the Joint Director of Health Services
Yes, sir.
is now being stated to be incorrect by a medical board of a selection committee.
No, Lordship, what happened, Lordship? Here, Lordship, chances of variations were there, Lordship. So, Lordship,
Kindly see page 27.
yes, Lordship.
Disability condition not likely to improve, nature of disability permanent.
Low vision, yes, Lordship.
Huh.
Lordship,
If you want to
this-
challenge the disability, you have to do it in the appropriate manner. Holding your own board and saying, no, I will not listen to you, are throwing the Person with Disabilities Act to the wind.
Then, Lordship, let it come after, Lordship, 30th of April, Lordship, because that
Any protection given? There is a protection. When? 30th of?
April, that matter is fixed. No,
30.
30 of April, read appeal. Similar matter.
What is this, my lord? They can
We are not going back there.
with an affidavit, my lord.
We are not going back there. You file your own affidavit in this.
Lordship, I will file my affidavit.
That is the question framed. Can certificate issued by under the Act be overridden by your private board, which has got no sanctity in law? What is that sanctity of that medical board?
Lordship, they have carried out this.
What is the sanctity of that medical board qua this certificate given under the Act? I have been declared to be a matriculate under the rules of the board. Yes. And tomorrow one person sitting in an interview board will say, no, you don't have enough knowledge to be a matriculate. We decline to hold you as a matriculate. Can he do that? Can he do that?
Lordship, otherwise there is an OM, Lordship. As per the
To
OM.
override the Act?
No.
If you say that he does not suffer from that disability,
OM is given
it is a fake certificate or the findings are wrong, hold the officer responsible who issued that certificate. He will go scot-free. This person with a certified disability will not get a job. Can it be so, sir?
Then thereafter, my lord, this petitioner, he carried out a private examination by a doctor of repute. That certificate is there, my lord. Otherwise.
Then what is the sanctity of a certificate of the Disabilities Act, under the Disabilities Act? What is the sanctity? Just tell us. When a person is a matriculate or a graduate and he sits in a competitive examination, it is not to see whether he is a graduate or not, whether he has got the brains of a graduate or not. What is evaluated? Competitiveness. With him, how much do you know? Is it not? Can you take away the graduation?
But Lordship, this is Lordship against one disabled person against another, Lordship. It is not like.
No. Am I disabled or not? That is all you need. There's a certificate. I am disabled. Certificate by whom?
Yeah.
Authority given by the Act. And then two private people will sit and you start rejecting. What is that? Keep in mind. He's looking at you very anxiously. Huh? When will you file your affidavit? Tell us. Affidavit by when?
2 weeks, Lordship.
Pick a date.
2 weeks, my lord. Let them file it by.
Pick up a date.
Lordship, 26th
Of April.
by 26th. No, Lordship, of March, Lordship.
March. Place this matter again on the 26th of
No,
March.
Lordship, I will file my affidavit on or before 26th, Lordship. Can it come on 31st of March, Lordship, so that they can also.
Hmm?
That is my problem, my lord. I'll see to it. Let him file the affidavit. So much concern about me.
Yes, miss. List again on ketia kolu? Of April, of March. By which time the respondent shall ensure that the affidavit in opposition is filed in the matter. Mr. B. Goswami appears for the petitioners and has expressed urgency in the matter. When there is a fraudulent, if you have any doubt on the certificate, definitely. Genuine certificates. Yes, sir.
Today is the fix for submitting the report, madam. Already two hearing has already been done.
Who is supposed to
But regarding
file what
by the
report?
Deputy Das.
Report regarding?
Regarding hearing Randita Borpatagua, regarding hearing at Commissioner and Secretary and thereafter Director.
This is elementary education. We'll wait for some time. Wait for 5 minutes.
But he says that he has accommodated me.
Huh?
Mr. Khatonia informed me just 15 minutes before. That he has they accommodated me.
Oh, they've accommodated you?
I-
Fantastic.
So-
Yes. Any instruction? Mr. MP, we are talking to you. You are a Department of School Education.
Yes, Lordship, but I'm in the secondary, Lordship.
Eh?
Khatonia-
Where is the primary?
NJ Khatunia.
Any tertiary is there?
Udyog disseminate.
Next Udyog. Ask Mr. Khatonia to be here if he
Fine.
can close it. Man? 50. Yes, madam.
Yesterday's case, my lord. I have gone through it, my lord.
Lordship.
Lordship is right.
Lordship, I have given a copy, Lordship. The second page, Lordship.
Hmm. Yes, 2020.
Extended.
So it is extended. What would you do? Take your instructions or we dispose it of?
Should we dispose it of?
Huh? That is the only stand,
Yes, Lordship.
that it was not done within the extended time. Is it not? Are we on the same case?
এইখনেই আছে, একটাতে আছে।
You have your doubts? See that time period to return the money has been extended. 2020 says it is extended.
And here, Lordship.
If I had not seen it, case would have been
Right.
dismissed. Huh?
I am very much grateful to your lordship.
No, no, don't be. We'll take it up for orders. নহয় এইটো হেৰি কৰক we'll dispose it of on the ground that the time has been extended by the amendment of 2020 since he has already paid the
might
money
not be-
prior to 2020.
Yes.
At that point of time, although she might not have been entitled to, but with this amendment, now she stands entitled, and therefore the director of the concerned department will immediately process the case for payment of the family pension and other values.
Thank you.
Ah,
Only pension, Lordship,
Huh?
family pension, only pension,
Hearing has been concluded.
only family pension.
Judgment reserved to RGPD. We are not dictating now, we'll dictate it later.
Problem.
Disposed of. Miss P. Bormon and Miss
RK Talukdar,
R.K. Talukdar, D.
for Respondent 5. Respondent 5, Accountant General, please.
Masul.
Item 51, my lord, I have received already yesterday.
What?
Matter pertains to arrear salary.
You received all the arrears salary.
Yesterday, my lord, item 51.
Item 51.
52 yet.
In view of the submission made by the learned counsel for the petitioner that the relief sought for in this writ petition has been granted, no further adjudication is required. Writ petition is accordingly closed. 52 Duke. Yes.
This yet to receive, madam. Have not received.
So we'll wait for some time.
Right.
We'll fix it in the first week of April. At the request of the learned counsel for the petitioner, who submits that similarly situated persons have been paid their arrears salary and there may be a process on for payment of salary to the present petitioner also list this matter on the April or did you go 6th of April?
Obliged.
None appears for the petitioner on call. List again on 25th of March.
On hearing on orders. Item 45.
As that relates to family pension,
Hmm.
the petitioner is the only legally married, the wife of the deceased.
No, what about respondent number 6?
Respondent number 6, the Lozima order is there.
What does it
Lozima
say?
order. That was long before served for the district court.
Okay. Matter relates to?
Family pension, because as per the affidavit of the AG,
Ah,
the family pension that the deceased husband declared one other lady, that is respondent number 6, in the PPU.
we'll take it up on a hearing day. It'll be easier. A hearing data deduction. But it will be in the month of April,
April.
21st of April.
Okay.
For hearing. Pleadings are complete.
It is complete.
All
Because
parties have been served.
Presumption is taken.
All parties have been served. Pleadings are complete. List again on so and so for 21st of April. 25th of April. April or 25th Sunday. 21st.
46.
Yes. Yes, tell us. Huh? Yes,
Lordship,
it is for orders. Why?
as per order dated 24/11/2025. Instruction was called for, Lordship.
Yes, higher education
Mr. A.R. Tabildar is looking into this matter. I'll call him also
after some time.
after some.
You think there is any time left?
He is coming, Lordship.
Huh?
He is on his. Lordship, he is here only.
Yes. No affidavit. Complied.
As per order dated, Lordship, 24/11/2025, Lordship. A speaking order was passed, Lordship.
Speaking order was passed.
Yes, that is.
Then after that, what happened? Huh?
Both the speaking order is also there, Lordship, and the subsequent order. Petitioner doesn't have the UEC norms of
Who does not have?
petitioner,
Huh?
so rejected.
Have you gone through this 13/3/2026? Go through it. When do you want it?
Next week.
Okay. 24th. List again on 24th of March, allowing the learned counsel for the petitioner to go through the instructions produced by the respondents on behalf of the respondents, claiming that the orders complained of have been complied with.
Speaking order has been passed.
That a speaking order has been passed and the orders non-compliance of which had been complained, have been complied with. Yes. 49 to 3. Mr. Khatwania,
Yes,
we'll close it.
And liberty may be given.
In view of the orders, in view of the order dated
It is dated, my lord.
11/3/2026. The learned council passed by the
Secretary, my lord.
Secretary.
Commissioner Secretary.
Passed by the Commission and Secretary to the Department of the Commission Secretary, Department of School Education, Assam. Mr. N. Bora submits that no further adjudication in the present writ petition is required in its present form. However, he prays for the liberty to approach again in case any grievance is left unaddressed. Full stop. Granting such liberty, writ petition is closed.
Accommodated tutor, that's that line.
উপর য'ত লিখিছিলো যে as far as where the petitioner has been accommodated as a tutor. এই হেৰি এটা আনি থবচোন হাতত দিয়া এটা কাঢ়ি পেলাই চুব ভাল নালাগে. Yes, sir.
This is a peculiar case where the husband took the interview of wife.
Acha.
Respondent number 7.
To marry her or for some other purpose?
No, her wife. His wife.
To marry her?
No, my lord. They got married.
Acha.
And thereafter interview took place.
Acha.
And 7 is the husband. He took the interview of his wife. That is respondent number 8. Now, also gave the numbers in the answer script. So, Lordship may kindly see we brought all these matters to the notice of the Honorable Court. And this Honorable Court by order dated 21/6/24, can we see the order? Asked to produce the answer scripts and others, etc. Thereafter, they have filed affidavit, but these orders have not been followed and no contents of these orders have been brought on record.
Yes, who appears for the water resource? You have the records with you?
No, your lordship.
We'll hold the director in contempt. We'll hold the director in contempt. If he is not producing the records as required by this court, we will hold him in contempt.
Intentionally, they are doing this because
Place the matter again on the 24th of March, on which date the Learned Standing Council for Water Resource Department shall produce the records of the test, interview, etc. in respect of the petitioner as well as the respondent number 8. Full stop. Have you stated in the affidavit in opposition that he is not the husband or wife?
They have filed affidavit,
What
last
have they
letter of this order.
What have they
But
said?
in order, they have not answered what your lordship desired on 21/6/24. They have stated nothing. Only casual things, this, I appeared, I got passed and I was appointed. So answer script they did not produce. And we have got the answer scripts through RTI. You can see the different right marks have been cut and marks have been deducted by her.
Yes, the affidavit in opposition does not answer the queries raised by this court on the date when the notice of motion was issued. In the failure of the respondents to produce the records on 24th of March 2026, necessary orders requiring the personal appearance of the director of the concerned department shall be passed.
Hello.
Get your records.
59.
Yes, sir.
A lot time was allowed for 3 months only to hold DPC. And much more time has been elapsed. And they have filed their affidavit, respective affidavit by both the contemners. Respondent.
I need to file another affidavit, my lord.
Saying what?
So we have completed the process, my lord.
Of the DPC.
DPC was completed
Ah,
and some documents were on shortage, my lord. We did not submit some documents.
who did not submit?
The petitioner, my lord.
The petitioner has which documents? Tell us.
And we have informed him also to submit those documents, my lord. This is a letter, my lord, we have given to the petitioner.
What is the letter? এখন দিয়কচোন পুৰা। Let's continue. Where is the earlier letter? Acha.
This is the DPC.
Relevant point of time is what time? 2013, you want documents of 2013 to be produced by him now?
The DPC, my lord,
Huh?
he has to submit his documents for consideration of the case by the DPC, my lord.
Kindly tell us one thing, sir. The case is decided in 2024. You are asking him to produce, that DPC was required to be held as per the then relevant rules.
My lord.
So you are now considering him in the year 2013. And he's supposed to take out the attendance sheets for the year 2013.
Some documents that are required.
That is what we are reading, sir. Are you reading that instruction you have given us? End of the day. List of supporting documents. Kindly see. List of supporting documents. What are you asking for?
That is not contemplated under the regulation, my lord.
Details of classes allotted and taken. Are you saying that he has not taken the classes?
My lord.
Is it not a way to just circumvent the orders of the court? We'll have the persons before the court.
There are other documents also. my lord.
Yes, what are the documents? Kindly tell us. Let us all read.
That is in the letter. my lord.
Documents related to the use of participatory and innovative teaching learning methodologies, etc. Documents related to evaluation of answer script. Is he entitled to retain them? Extension, co-curricular and field-based activities, contribution of corporate life and management of the institution for the year 2013.
No, my lord.
That is what we read in the order. That is what we understand from the order. You are supposed. Do you ask these documents from every person who appears in the DPC?
My lord, we submitted our reply to this letter.
Hmm.
It is at page 50 of our affidavit.
Hmm.
Well, I'll file legal reply, my lord. I'll file a legal affidavit, my lord.
No.
Every time it comes up, this thing.
Since so-and-so could not produce some of the necessary and relevant supporting documents before the DPC scrutiny committee, what kind of documents and are you expecting? Are your clients expecting? Somehow we are having a feeling that this is only to when last 3 minutes are left in the game, the ball is passed between the players, not allowing any more scoring. This is what is happening. Rotate the ball so much that the other party gets frustrated. We are not happy. The order dated 29/11/2024 passed in WPC number 2154 of 2023 had required the respondent authorities to complete the process of consideration of the case of the petitioner for his promotion to assistant professor stage 3 in accordance with the rules prevalent at the relevant time within a period of 3 months from the date of receipt of certified copy of this order. In your affidavit, you have filed your affidavits? What is your stand taken?
But initially, my lord, we had written to the Vice Chancellor for the nominee, my lord. That nominee was not there, and ultimately the nominee came, my lord. So that we then we constituted a DPC and completed the process, my lord.
The affidavit of the filed by the respondent number, who have all have filed?
Both the respondents filed.
By the where is the respondent number one? What is his name?
One number is the president of the committee. Respondent number 2 is the principal.
Yes, sir. It's trying to trace out. Oh. The respondent number one in the affidavit in opposition has stated that the petitioner was requested to submit all relevant documents to him in terms of the directions of the Honorable Court and meet the IQAC coordinator of the college. It is a further stand that by a letter dated 25/2025, the respondent number 2 had requested the academic register of the Gauhati University to approve the Vice Chancellor's nominee. Full stop. The affidavit of the respondent number 1 does not reveal as to what are the shortcoming documents. Further, there is nothing on record, nothing brought on record to show that steps were initiated within a period of 3 months for for requesting the Gauhati University to approve the Vice Chancellor nominee and panel of experts for Departmental Promotional Committee. Full stop. Although there is a letter dated 25/2025 annexed to the affidavit in opposition, affidavit, the next letter brought on record is of 30/10/2025 without there being any explanation as to what has been done in the meantime. Full stop. The affidavit of the respondent number 2 is similarly worded as that of the respondent number 1 and contains the same document. Full stop. This court does not appreciate the manner in which a delay is being caused in complying with the orders of the court. Full stop. Affording one more opportunity to the respondents to complete the process of the DPC within a period of a month from today, list this matter again on today is 16, 16, 20, 20th of April, by which time the respondent shall place before this court the compliance order, the compliance report of the orders of this court. Full stop. The learned counsel, the learned senior counsel, the petitioner is expected to extend cooperation by participating in the DPC if and when required within this period. They will have to take on record whatever is there and then take a decision.
Things are like
They cannot simply say that we want to give me more paper, give me more paper, give me more paper. You don't find appropriate papers, you reject him, sir. Mr. Borua, you reject him.
everything was submitted, Lordship.
Otherwise, they cannot call for nominee, etc. That process comes later. They must.
20th, either there is a compliance report.
I'll ensure that.
একদম উপর লিখিব Mr. C. Chaudhary, learned senior advocate, appears with the assistance of Mr. N. Bora appears for the respondent number 1 and 2. This round thing is something we are not appreciating. This way, that way we would have appreciated. Yes, it will not clear.
In this matter, we have filed our wakalatnama. Not yet come, the name does not come, my lord. Ultimately, I'll take my, I'll get my instruction.
That recently is nearly 1.5 months ago, on 4/2/2026.
Oh, it's not come, somehow.
Too recent.
I'll have it after
List again
3 weeks.
on the 6th of April, allowing the respondents to file their response.
Deeply.
Hmm.
The order starts at page 11. Portion, the order is at page 65.
Yes. Respondent number 1, no such address.
Yes.
What do you want to do? Respondent number 1, no such address. Respondent number 3, insufficient address. Respondent number 2, affidavit not filed. Now tell us. This is what you should look into.
We have also submitted
The petitioners are given the liberty to trace out the appropriate addresses of the respondent number 1 and 3 and inform the court or file application for amending the cost title. Respondent number 2, who is represented by Mr. P. Nayak, would be at liberty to file a response in the meantime. List again on the 8th of April for the petitioner to bring on record the correct addresses of the respondent number 1 and 3.
Be it after vacation, Lordship. In the meantime, my appeal is already pending there and probably it will be taken up, Lordship.
Then we'll take it up. Then we'll take it up on the 20th, or maybe later.
After vacation on
27th.
27, right.
27th of April. If you file an IA before that, we will issue notice and you can get the others served.
Oh.
Yes.
Lord, respondent number 8, they filed their, we filed our rejoinder also. So, my lord, perhaps.
Your rejoinder is not on record.
My lord.
The rejoinder filed by the, stated to have been filed by the petitioner is not found on record. Registry to trace out the same and tag with the records. If there is no office objection, list the matter again on, is it urgent?
My lord,
Or can we have it after the vacation? Huh?
Petition from service, he was the, my lord, SP of the wrong district. So, my lord, legal urgency is there because he will be superannuating on next coming year. This year only.
He is dismissed from service. He is not superannuating, my lord. Unless he
I
is.
mean, if this.
If he is reinstated, he will superannuate it in the next year. When? Tell us.
This one, my lord, last week, any date.
Let it come after, my lord, due vacation, my lord. It has come for final.
My learned friend did not object, my lord, because
Your affidavit is on record.
his affidavit is on record, my lord. My affidavit is to come, my lord.
7th of April.
My lord.
7th of April.
I prayed for after due vacation.
List this matter again on 7th of April, despite objections being raised by Mr.
Deeply obliged.
No. We'll keep it on the 21st of April.
My lordship,
It is only the one week vacation in between.
only for my affidavit.
No,
That has
we are fixing it on a
admission.
on a hearing date.
My lordship.
Time permits, will take it up for disposal.
Deeply obliged. Deeply obliged.
My pleasure, Lord.
Yes.
But see, basically, I have two prayers in it. One is for reinstatement by setting aside the suspension order, and one is for staying the disciplinary proceedings. So, as has been arising from the same set of facts in the criminal proceeding. So
When you could
basically,
not get it in the
Look at
writ petition,
my lord,
when you could not get it in the writ petition, why try it by way of an IA? That interim order you did not get in the main writ petition.
Yes,
Why try it by an IA?
but,
Let us go for a disposal.
but in the main writ, in the order, my lord, itself, it was observed in the last order, my lord.
Hmm.
So that continuation of the disciplinary process may be considered after returnable death. So that was an observation also. As saying the time, my lord, so that issue may be, but today I'm pressing only for the reinstatement, my lord.
Reinstatement by?
It's more than 1 year, my lord,
Of?
from the date of suspension.
They have reviewed it?
No, they have just passed passed a speaking order.
When?
I have annexed it in my
At?
additional affidavit. So I
When?
filed it, my lord, at page 52,
No, no, no. When were you suspended?
16/2,
16 to
2025.
2025.
Yes,
90 days gone.
90 days gone.
Then? No review.
No review.
No review.
No review.
Then you approach this court.
Yes, I've approached this
After you
court.
approach this court, they pass a
They have
speaking
passed
order.
this order, yes.
No, no. They are saying it otherwise. Just a minute. Can you give us some dates? When were you arrested?
Arrested on 5/2/2025.
Huh?
5 to 2025.
Arrested on 5
2 to 2025.
to 2025. When did you get bail?
My lord, on 18/3/2025.
When did you inform them?
Thereafter, my lord,
When?
immediately on the next day, my lord, not on the next day, it was on 15th, as per my instruction, my lord.
15 of?
15/2, 15/3, sorry.
You are released on bail on 83. You informed in
No,
15.
sorry.
Have your facts stated, sir?
No,
We are
no.
at the end of the
No,
end of the
15/4,
court.
15/4.
24th. 24th, we'll take it up. We don't have the time now to calculate all this. If it was 1, 2, 3, 4, we would have done it. Yes,
P6. 24th March, my lord?
March.
March only.
But there were two reliefs sought for. One was some arrear salary that has already been paid.
Mm.
And as far as MSAP is concerned, my lord, the respondent number 5's affidavit said that the proposal has already been forwarded now to the inspector of school. The procedure would be now that the IS will send it to the director, who will place it before the grading committee.
It is stated by the learned counsel for the petitioner, Mr. B. Pathak, that the arrear salaries have been paid. However, the case of the petitioner for consideration of the benefits of the MACP have been forwarded, is under process as per instructions received by him. Accordingly, list this matter again on 24th of April, by which time the respondent shall ensure that the status of the process being taken up for grant of the benefits under the MACP is placed before this court invariably.
Obliged.
Hearing was in. Oh.
So this matter, some other date we were taking.
2016, saved by the bell. Pleadings are complete.
Yes, Lordship, pleadings are complete.
Regarding what?
This is retirement of being on suspension.
Huh?
He has retired while being on suspension.
Did you what do they call, review it?
Lordship, there are certain things that we have brought on an affidavit
What?
regarding his claim is for subsistence allowance.
Have you paid it to him?
Lordship, he has not, as per our affidavit, he has not submitted this non-engagement certificate. Therefore, he has not furnished that.
No, he has not paid for subsistence allowance. He has paid for GPF, pension, arrear outstanding salary and other allowances. None appears for the petitioner. Call matter is of 2016. Prayers are for payment of retirement dues and arrear salary. Full stop. list this matter again on 28th of, no, 21st of April for consideration. Did I say none appears for the petitioner? Mr. So-and-so appears for, you are appearing for?
Lordship, I am appearing for respondent number 2
Ah.
on behalf of SK Midhi.
You have to give the name, your name. And you, sir?
AK Ghosh on behalf of Mr. King Kumar.
Done. Next. 45.
Matter pertaining to departmental proceeding.
Ah,
Penalty of, my lord, reduction of salary by 2 stages permanently.
Hmm.
So twofold grievance. One is penalty.
Hmm.
Second is with regard to after that, there was no promotion to him.
Hmm.
His entire service.
Hmm.
So
grounds of challenge?
grounds of challenge, perversity and violation of natural justice. Perversity in a sense that he was charged
Hmm.
basically for issuing a cover note
Okay.
for insuring a vehicle,
Hmm.
and that vehicle got, you know, succumbed an accident on the very next day. 20th, the cover note was issued by the petitioner,
Hmm.
and the vehicle met with an accident on 21st.
Hmm.
Now both the charges, basically primary charge is charge 1. Charge 2 is incidental,
Ah.
charge 1.
Ah.
Now on, after the accident, after 9 years, they have issued the charge sheet. The
Hmm.
incident happened on 2001,
Hmm.
27 2001. They have issued the charge sheet on 16/9/2009.
Okay, there was,
And
he
the
deferred with the inquiry officer.
sorry, Miller.
He deferred with the inquiry officer, disciplinary
Inquiry
authority.
officer, because Article 1 charge is held to be not proved.
Ah.
But he held Article 2 charge to be proved,
Ah.
which is incidental to Article 1 charge.
Ah.
And there is a disagreement note, and the disciplinary authority disagreed by relying on a preliminary inquiry report, which was never part of the charge, departmental proceeding or part of the charge sheet. And the most important on merits, Miller, most important aspect is that the policy was issued on 20th itself.
Hmm.
So how can you maintain a charge basing on a cover note? That policy I have annexed in the additional affidavit. Where do you stand? Can it be, if possible,
Yes.
subject to convenience, my lord.
Hmm.
Next week, my lord, 19th, if
Next week, 19th.
possible, my lord.
Next week, my
It's
lord,
only a prayer, my lord.
lot of cases, and in the meantime, my lord, yesterday they filed an additional evidence.
Additional
shall have
affidavit,
to-
I'm sorry.
Let me say, we shall have to look into that and whether the
He has
client
to have his
want
instructions.
want to say
But it's
something.
fine. My lord, I'll just clarify why this additional affidavit, since I said that I was deprived of promotion because of this thing. So what way those promotion, that I have brought on record, nothing more than
No,
that.
whatever it is.
Page affidavit.
No, whatever it is, he will have to have his instructions.
Can it be sometimes in the, my lord, in this month, my lord, lot of cases, in the first week or second week of April?
Second week of April prior to Bihu, it will be a heavy board. Anyway, list again on the 7th of April,
Yes, that was.
Seven?
Seven, take a second.
Tuesday,
Yes, Tuesday will be
Tuesday,
better.
7th of April. Pleadings are complete. The learned senior
Of
counsel,
our pleadings concerned, if this.
the learned senior counsel for the respondents has submitted that he would have instructions whether he would be required to file any response to the additional affidavit filed day before yesterday by the petitioner.
Exactly. Much of it.
Sir, Lordship will keep
Part had
Thing is,
if,
from 30 to 10, I'm not keeping anything part hard.
oh, fine, no problem. Highly agree.
Obliged.
Because the ears may not be here to hear. No part hard. Yes,
So nice of you. Highly agree.
30. It again 47.
47.
47. Yes, good chance. Hammer it. No one on the other side. Good chance. Hammer it. Finish it. Tell us. We want to dismiss this. Tell us.
My lord, we have received our instructions just now, my lord. We have constructed the file yesterday.
Oh, acha.
My lord, may disposes of this matter by looking into this instruction, my lord, short instruction. My lord. So the petition again, we can advocate the point, my lord.
Mr. So-and-so and counsel appearing for the respondent has submitted that the original file had been misplaced and
We have reconstructed.
and has been recently reconstructed, and they have received instructions recently. Accordingly, he prays for some time to acquaint himself with the matter. List the matter again on 6th of April, no, 7th of April. None appears for the petitioner on call. Hetu ekdam upor dibo. Hmm.
I'm appearing for on behalf of Mr. A. Khonikon.
A?
A. Khonikon.
A Kolita, yes.
Matter we take care of before Bihu vacation.
Today is before Bihu vacation.
Lordship.
Tell us, what is the matter about?
Lordship, petitioner applying for a post of assistant lab technician
Hmm.
conducted by AIMS Delhi.
Hmm.
And the respondent of AIMS Gauhati.
Achha. Pleadings are complete in the matter and it was listed under the hearing column. However, paucity of time does not allow the matter to be taken up today. Accordingly, list the matter immediately. You want it before Bihu vacation? 2nd of April. That's okay.
Please, your lordship, the matter may be possible for the day. I, on behalf of S. A. Ahmed.
Huh? Yes. Police constable. Dismissal. I think if you have the records, it will suffice. When the affidavits are there, when 2017 matter, dismissal from service. This way, that way. We'll take a chance on 27th. 27th. The matter relates to dismissal, the termination from service of the petitioner. Pleadings are complete. Respondents may have the records of the proceeding made available on the next date of listing. Huh? Good. Anything left, sir? Anything, sir, left? No. Thank you. Thank you so much. Thank you.